The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Morning, Mr. Gray.
Good morning, Commissioner. Good morning, Commissioners. Today, we're going to start by calling the CEO of Comcare, Ms. Sue Weston, PSM. Ms. Weston's already in the witness box awaiting affirmation or the oath.
Before we do, there's just probably two issues, if I may.
Sir?
One is we do have an announcement to make, and two, are there new appearances to be announced or not?
I think there may be.
There are, Commissioners. If it please the Commissioners, my name is Craig and I appear with Miss Goldstein of Council for Comcare.
Thank you, Mr. Craig. Okay.
And we also have Junior Counsel for Comcare present in the hearing room.
Thank you. Overnight, the Attorney-General announced we've been allocated an additional 12 months to prepare our final report. The final report is now due on the 17th of June 2024. The interim report remains due on the 11th of August 2022. In approving this extension, the Government acknowledged the significant volume of work the Royal Commission has undertaken to date, with more than 1,300 submissions received so far and 344 requests for private sessions, as well as the completion of 3 hearing blocks, with this being the 4th, from which significant evidence has been gathered. The engagement with the Defence Force and veteran communities has been extensive and essential, and there's much more to do. The magnitude of the task has now become clearer. Given the need to undertake a more detailed inquiry, harnessing the contact with the community and continuing our own research and analysis, we sought the extension to allow the following: to allow adequate time for continuing engagement with the Defence and veteran community and other relevant stakeholders, to allow us to pursue our ambitious data gathering program to analyse the results and test them against other evidence. This will inform our recommendations, including the need to have in place information systems designed to help reduce the number of deaths by suicide in our military and veteran population, to conduct further roundtables with experts on suicidality in the Defence and veteran community and more generally. These roundtable discussions have been very helpful to date in directing our thinking about the contents of our hearings and the importance of various areas for research. With the extension of time, we'll be able to conduct more of these roundtable discussions, consolidating the robustness of our evidence base, and we'll also have time to socialise and test possible solutions prior to publications of the final report. To allow us to properly examine how our allies in the US, the UK, Canada and New Zealand in particular deal with this issue and learn from their experience as per our terms of reference. And finally, to safeguard our own workforce and that of the Commonwealth staff who are responding to our demands and participating in our inquiries. The work has been intense. The focus of our interim report will be urgent recommendations for early actions that may be taken now. If required, the Royal Commission may consider making other urgent recommendations prior to the release of the final report if it is deemed necessary. We are also considering the possible requirement for an agency or body that may follow the Royal Commission, akin to the Government's previous proposal for a permanent Defence and Veteran Suicide National Commissioner. We plan to consult stakeholders on this issue and receive submissions before making a recommendation to Government. Thank you, Mr. Gray.
Thank you, Commissioner. I tend to ask questions of Ms. Weston and to allow you, Commissioners, to ask questions of Ms. Weston for about 2 hours from this point. And then after a short break, I understand from about 11:45, we'll be calling a Defence Register panel comprising David Morton, Director General, Health Policy Programs and Assurance, Captain Glenn Kerr, Royal Australian Navy Provost Marshal, Joint Military Police Unit, and Brigadier Eamon Lenigan, CSC, Deputy Head of Task Force supporting the Royal Commission into Defence and Veteran Suicide. After lunch, there'll be a Defence and DBA access to information panel comprising Dr. Tom Clark, First Assistant Secretary, Enterprise Transformation and Governance Department of Defence, Monique Hamilton, First Assistant Secretary, Service Delivery Department of Defence, Air Commodore Steve Martin AM, Director, Special Projects Department of Defence, Rachel Goddard, First Assistant Secretary, Commemoration and Transformation Division of DBA, and Moira Campbell, Assistant Secretary, Client Access and Rehabilitation Branch, DBA. And then at the end of the day, we'll be calling for a brief session, the Australian Information Commissioner, Angeline Falk. Ms Falk's Australian Information Commissioner and Privacy Commissioner. So I'll proceed now to the examination of Ms Weston of Comcare. Comcare, as you'll appreciate, Commissioners, is regulator of the Commonwealth Work Health Safety Act and Framework. Comcare also has a workers' compensation function in relation to the workers' compensation scheme under the Safety Rehabilitation and Compensation Act. But this is not a scheme that applies to ADF personnel, so that won't be the focus of the examination. I'll ask the operator to display a tender bundle of documents relating to Ms Weston's evidence and her topics that she's addressing. And these are documents that have been, in the main, produced on notice by Comcare. And Ms Weston's also prepared a statement on notice issued to her from the Royal Commission. If do you see the tender bundle list has appeared, Commissioners, on your screen? That's the first page. I'll just note that the first item is Ms Weston's statement in response to a notice. Ms Weston, I'll just ask you I'm sorry, I don't think we've administered the oath or affirmation yet, so I'll ask that you be administered the oath or affirmation. Thank you.
Susan Weston, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do. Oh, I do.
Thank you, Ms Weston. The operator will now display the first page of the statement you prepared on notice you received from the Royal Commission, SWE.000.0001.001. That's item 1 in the tender bundle list that's currently displayed. Ms Weston, do you recognise that as the first page of the witness statement you've prepared?
I do.
And that's a witness statement which I think you dated 7 April 2022 and signed on its last page, and it comprises 54 pages.
Yes,
Thank you. And to the best of your knowledge and belief, are the contents of the statement true and correct?
to the best of my knowledge.
Uh,
Yes, they are. Sorry,
they
to the
are.
best of my knowledge, they are true and correct.
Thank you very much. And Commissioners, I'll be tendering that as item 1 in the tender bundle. I'll just mention the other matters in the tender bundle. With the exception of 3 documents, items 41, 43 and 44 that have the exhibit numbers there mentioned, all of the other documents in the list are fresh documents, and I'm tendering those along with Ms Weston's statement. Some of them have been partially redacted or are redacted for publication. I tender those documents.
There's an objection at the moment unless they're tendered on a confidential basis. We are having subject matter experts look at the particular documents to check for sensitivities.
Are there any documents in particular that you seek should only be tendered on that basis, or are you talking about the whole bundle?
Everything but document 1 at the moment.
Well,
Yes.
Commissioners, I don't accept that there should be a non-publication direction made in relation to everything but the statement. And I'm happy to have conversations with our friends for the Commonwealth following Ms Weston's evidence about the proper extent of any non-publication direction that might be made about any of them. Perhaps we'll just, if I might suggest, we just tender these documents on the understanding that there will be discussions about the proper scope of any non-publication direction, and we will proceed on a document-by-document basis through the examination, and where I seek to display a document and my friend actually has a concrete objection to that document being displayed, he can raise that complaint then.
Can I just raise this issue?
Yes.
I accept that not everything in that list will be the subject of an order. That must be correct. But I'm uninstructed. We've been given the documents. We've had subject matter experts looking at them since they became available first thing this morning. We are working as fast as we can. And as soon as I can inform my friend as to what there is no problem with and what we need to have a discussion about, I will do so.
Thanks. Is it feasible to proceed as Mr Gray suggests at the moment?
No, because I'm not in a position to take an objection until I get the instructions. There are two particular documents that Mr Gray wishes to take the witness to that I'm aware of. I have been out of the loop on those documents, but Mr Dighton Malena Jr will be able to take whatever objection is necessary in relation to those documents. I know that one of them has some sensitivities in it, and Mr Gray was looking at a way of moving around those. Now, I am not in a position to comment on whether that's acceptable or not, but I'll leave Mr Dighton to have that fight should it occur.
Well, surely we could pause when it comes to those particular documents.
Yes, but that leaves 40-something or 39 documents that I simply don't have instructions about. I can see a few there that I can't see a particular reason why, it's just that I don't have the instructions.
Mr Gray?
Well, a couple of things are a little unsatisfactory in my respectful submission. The first is that on my instructions, the Commonwealth had access to those documents late, very late, but late on Friday, not first thing this morning. And so one would expect that they had the opportunity and could have availed themselves of the opportunity of looking at these documents over the weekend. And that's regrettable, but that's just the nature of Royal Commissions, that one has to work outside normal hours. But my friend said that the subject matter experts only had those documents available to them first thing this morning. That's a matter that really needs to be looked into. Perhaps my learned friend's right, but on my instructions, it's a surprising assertion to make.
Well, there's two things to say about that. The first is, yes, the documents were, or the list of documents was received late on Friday night. It's one thing to release it to the lawyers and whatever team we are supported by, but where we require subject matter experts to look at them, it's a question of availability. So at no stage have I asserted that we got the documents this morning. The ability of the people I need to look at them is the question. They are doing it now as fast as they can.
The second somewhat unsatisfactory thing is that Mr Fordham is now saying that we can't display any of the documents, but that without going into the details of discussions that have been taking place, it was not my understanding that the Commonwealth would be objecting to us displaying any of the documents in the list. And there have been discussions about this morning. If the Commonwealth's going to object to the display of any of the documents in the list, then the examination is really deprived of quite a lot of its utility at this point in time.
Can I just take some instructions on an issue that may...
Thanks. Yes, I was going to suggest that.
The documents that I am now told are in issue are 8, 11 to 20 and 30. But we've also been told by the council assisting team that the two documents that they wish to display are 31 and 40.
31 of which?
And 40. So all I would ask is that a temporary order until I can get instructions be placed over 8, 11 to 20 and 30. And if it's not intended to go to them, I can't actually see the problem.
How does that affect you, Mr Gray?
Yeah, I can work around that, Commissioner.
Okay.
And to the extent possible, I'd understood that I could display 31 to the extent that I wish to, but perhaps I misunderstood since we're going into the detail of these discussions. And with 40, I do understand that Defence wants more time. That's difficult. I do wish to refer to some of the detail in that document. I might be able to do it without displaying it, but I do wish to refer to some of the detailed substance of what's in document 40. That's a risk and analysis assessment RNA, that is intelligence report, suicides and mental health, Department of Defence, February 2021, which is quite an important document in this tender list.
Sounds relevant.
I don't want to go into the detail of discussions between council, but I understand a proposal was put as to how 31 could be dealt with. My instructions are we can work within that.
All right, let's start.
40 is the issue.
See how we go. Thanks.
So, Commissioners, I'll start by asking you, Ms Weston, you've been very patient, thank you. Some questions by reference to contents in your statement, and Operator, if you'd kindly bring Ms Weston's statement SWE 000000010001 back up again, and we'll go to page 3 beginning at paragraph 13. Ms Weston, I just want to ask you about the general work health and safety functions of Comcare. And you say in paragraph 15 that Comcare is responsible for regulating the Commonwealth's work health and safety jurisdiction under the Work Health and Safety Act and regulations. Is it the case that there's a 3-level framework for regulating work health and safety, also including model codes of conduct?
So the Workplace Health and Safety Act, Mr Gray has an act, regulations and codes that operate.
Yep. And Comcare is in effect the regulator of that regulatory framework comprising those 3 tiers of legislation and legislative instrument, is that right?
So the Comcare is regulator under the Commonwealth version of the model workplace health and safety laws, and obviously there are other regulators who regulate under their version of the model workplace health and safety laws, which would include the regulations and the codes.
And you're the Chief Executive Officer of Comcare?
Yes.
And you've been the Chief Executive Officer since April 2019?
Correct.
And I understand there's been an announcement. Have you made an announcement that you're retiring quite soon from that role?
Yes, I'm retiring at the end of April.
Thank you. And, well, it's fortunate that we have you here to give your evidence now to the Royal Commission on the important functions of Comcare and its insights into work health and safety and defence. Can I just ask how that comes about, that Comcare has that work health and safety regulatory function with defence? You mentioned that Comcare is the regulator of the Commonwealth WHS framework, not the various other jurisdictions. And in addition to Commonwealth entities such as departments, it's the case, is it, that Comcare has that regulatory role in relation to the ADF itself, the Australian Defence Force itself?
That's correct.
understand, and you speak in paragraph 16 of the kinds of authorities and entities that are subject to the Commonwealth WHS Act. That's on page 4, paragraph 16. And just perhaps before I ask you a little bit more about the detail of how the WHS framework comprising the Act, regulations and codes work, could I just ask you a little bit about the internal organisation of Comcare? I think you refer to this on page 3, back on page 3. At the top, you identify 6 groups, A through to F, and just focusing not on the administration of a workers' compensation scheme under the Safety, Rehabilitation and Compensation Act, because that doesn't apply to the ADF as I understand it.
Not to the ADF, no.
No, just that's the work of the claims management group at A, is it? But that's not relevant to the ADF.
To the extent of this inquiry, there may be former ADF people who gain employment in other parts of the public, the Australian government sector, who have a claim and they may end up being looked at in that claims management group.
I see, but
it's not the ADF, no. The ADF isn't. DVA looks after that.
DVA looks after, in effect, safety, rehabilitation and compensation for ADF members and former members. Thank you. And then there are other groups, corporate, legal, I think we'll pass over those. Regulatory operations, is that the key group of relevance for the purposes of this inquiry?
It's the key group.
That is the key group?
Yes, there are obviously other groups assist. There are enabling groups in that list, corporate and legal, and strategic partnerships and engagement that support regulatory operations, and indeed scheme management, because they look after our data holdings, some of our data holdings.
Thank you. Scheme management, beg your pardon, maybe if you move the microphone a tiny bit closer to you, we might be able to hear a little bit better. Thank you. What did you say scheme management does in support of regulatory operations?
So our scheme management groups looks after the policy of the safety, rehabilitation and compensation arrangements, but they also are responsible for our data holdings, our data policy, for instance, and that supports regulatory operations as well.
Thank you. And strategic partnerships and engagement, a little later in your evidence you describe such things as the Defence Comcare Liaison Forum. Is that group, or is that forum within the purview of this group on strategic partnerships and engagements?
Defence Liaison Forum is largely attended by regulatory operation group, the general manager and the regional managers. So it's actually up in that regulatory operations group. It's supported by strategic partnership and engagement in a number of ways.
All right. Does strategic partnerships and engagement have a direct role connecting Comcare with Defence?
Strategic partnerships and engagements engage with Defence, particularly in relation to education and training. That group do the outreach on education training and do provide one-on-one or agency by agency training arrangements, training or what's determined might be needed. So they also look after research and other things that may be relevant to strategic operations, regulatory operations, beg your pardon.
Thanks very much. Could I jump back to where we were in the statement at page 5 now and ask you a little bit by way of explanation of the WHS framework comprising Act, regulations and code. You give a very helpful, if I may say so, tutorial in the way the framework operates from paragraph 19 on page 5. And just to summarise this for people listening, if you would, you start with referring to persons who conduct a business or undertaking, PCBU, and they are the entities, are they, to whom or to which obligations under the WHS framework attach?
So a PCBU, as in my statement, is responsible, they have a primary duty of care to ensure the health and safety, the physical and psychological health and safety of the people in that PCBU. And sometimes we might use employer as a proxy for PCBU. That might be helpful sometimes.
And I will generally, at this point, stick to the general and the abstract, but I just want to ask you one specific question about defence here. Who is the PCBU, do you know, when it comes to defence? Is it the Secretary, the Chief of Defence Force, or some combination of the ADF and the Department, or the Minister, do you know?
The PCBU is the Commonwealth, for Commonwealth departments and agencies, and is activated, I suppose, by the heads of those organisations and officers within those organisations who have duties as well.
Thank you. And you say at the foot of paragraph 19 that health is defined within section 4 to mean physical and psychological health. And that's an important element of the 2011 Act, which differed, I understand, from earlier incarnations of occupational health and safety legislation. Is that right?
I would need to take that on notice about the former Act. 2011, the 2011 Workplace Health and Safety Act started on 1 January 2012, and it moved to a criminal jurisdiction, so there was some changes to the previous arrangements. I do recall reading something about the move for psychological health to be included, but I would need to just clarify that for you.
That's fine. Thank you. And there's that key duty which is imposed by section 19 of the WHS Act, I understand, and that's that duty to ensure a physical and psychologically safe and healthy workplace. In addition, there are a number of other obligations. You deal with notifiable incidents at paragraph 24 on page 6 and following. And you describe the scope of what must be notified as a notifiable incident over the succeeding couple of pages. And then at paragraph 29, we'll come back to this in due course, you note that there are limitations on what must be notified. Would you just explain that to the commissioners?
Yes. The notification provisions in section 35 through to 38 do have some impediments for us as a regulator. Section 35 defines what is a notifiable incident and includes the death of a person, a serious injury and a dangerous one. When it comes to the provisions in section, particularly 36 and 37, are very prescriptive, and largely to see a serious sexual assault or a physical assault, you need to be the injury needs to be sufficient to be considered for an inpatient at a hospital. That doesn't always happen with these type of injuries. And in addition, section 38 puts a duty on the PCBU to, they need to determine whether the incident arose out of the workplace of the business or undertaking. And it may be that we don't see those because of that assessment.
So the incident, as well as meeting those objective descriptions, death of a person, serious injury or illness of a person, or dangerous incident, must be an incident that arose out of the conduct of the business or undertaking in question. Is that right? Now, in paragraph 29, you say incidents involving harassment or bullying, psychological injury or illness, serious physical assaults and or serious sexual assaults fall outside the scope of notifiable incidents or dangerous incidents, save for, and I'm paraphrasing, where there's either death or treatment as an inpatient, or there should be treatment as an inpatient in a hospital, or treatment for physical injury or medical treatment within 48 hours in certain cases. And there's no express reference, at least, to psychological injuries or illness.
Correct.
So what are the implications of that? Unless, just say there is the infliction of psychological harm, unless there's in effect hospitalisation almost immediately after the relevant incident, is it the case that there is probably no legal obligation to treat the matter as a notifiable incident and report it to Comcare as such?
So if it doesn't pass the notifiable test, that is the problem. We don't get the visibility of it in that way.
Now, Ms Weston, you refer in your statement to various other functions of Comcare, inspectorate functions, including what? The ability of inspectors engaged by Comcare to investigate particular matters. Is that what an inspection is?
So as a regulator, we undertake a number of tasks. Regulatory pyramid, you have some enforcement action at the top, so you would have the serious investigations happening up there. And the body of the framework is inspection work or WHS audits or, some of the other provisions we have available to us, improvement notices, prohibition notices. Education perhaps is in that space. That's the bulk of where our work is. An inspection might be going proactively or reactively to look at what's happening in a workplace. And of course, down the bottom is the education, important education piece for a regulator.
Thank you. And going higher up the pyramid, either as a result of inspection or perhaps independently, there might be more formal or more serious compliance action, is that right? Formal investigation, is that one?
Beg your pardon. So at the top end of our regulatory pyramid, our investigation is operating on the basis that it may be a move to prosecution, and so the collection of evidence and information is with a view to that in mind.
So in the terminology of the legislation and of Comcare itself, inspection shouldn't be confused with investigation. So pardon me for doing that a minute ago. It's a form of inquiry that is perhaps will never result in investigation, but may be antecedent to investigation.
Indeed.
And investigation may lead to even greater levels of compliance activity, such as prosecution.
Yes, so an investigation, we think there's a prospect of moving to that phase, but similarly, it may also be de-escalated to an inspection where it could be, the issues could be dealt with through some of the other enforcement powers we have.
And Ms Weston, can I ask about what might be occurring in parallel with those things or maybe happening separately from them, and that's the more consultative functions that you describe in the statement, where Comcare has a role of providing information and guidance to PCBUs, thank you. Could you describe that function in an outline form?
So around 2018-19, Comcare put together a strategic partnership and engagement team with specific focus to reach out to the jurisdiction and try to meet our objective that PCBUs, employers in our jurisdiction, are able to meet their regulatory operations largely through their own actions And so it's an educative piece. Also, things change. Of course, we've had the pandemic for a couple of years, so they've had a key role there in making sure the jurisdiction knows its obligations as they were coming through during that time.
Thank you. Now, I just want to ask about other ways in which information might come to Comcare outside the process of there being a formal notification of a notifiable incident. Those constraints on the definition of notifiable incident in paragraph 29 of your statement suggest that there's going to be a real difficulty in Comcare receiving at least timely information about what I might call psychosocial risks. Would you agree with that?
So, first of all, if I might just put a context, PCBUs have an obligation to identify the hazards they have in their workplace, of which psychosocial hazards are one of those. They need to then risk assess. They need to work out what controls they put in place. They need to then consult with staff and review. So it's a general framework for how it operates. So, and so even though there's no notification provisions that are helpful, they still should be doing that, all PCBUs. Nevertheless, we have tried to create pathways to get the sort of information that we feel we need to check on that framework being put in place. So we have instituted what's called WHS concerns.
Could I just ask the operator to bring up the relevant document? COM stop 0001, stop 0002, stop 0562. Thanks, Ms. Weston. I didn't want to interrupt, but this might be a useful reference point for you.
Is that the one on the slide? Is that what
no, we're just waiting for it to appear.
Sorry.
COM stop 0001, stop 0002, stop 0562. That's item 28 in the tender list. This is a document entitled Notifications, WHS Concerns and Help Desk Procedure, Risk and Analysis. And you just a minute ago mentioned WHS Concerns as one of the other avenues by which you might obtain information which might extend to psychosocial risks.
And does. So yes, WHS concerns, other intelligence, complaints, and people reaching out to the help desk, media responses, those sort of things we ingest as potential issues that could identify a PCBU not meeting its obligations about keeping their workplace psychologically or physically safe.
Thank you. Now we'll just go to page 16 of this document. We don't have time to delve too deeply into this, but on page 16, that's 0577, there's a page entitled WHS Concern Specifics, and there are various WHS concern types. Perhaps that's self-explanatory, and one of them is workplace bullying allegations, and there's a link to a psychosocial inspections guidance for monitoring compliance procedures. Is this document an internal Comcare document for guidance to staff, including staff on the help desk? Am I interpreting that correctly, Ms. Weston?
I think so, but we'll check that for you.
And are you able to give the commissioners just a brief summary of what a psychosocial hazard might be or a risk might be in the workplace?
So there could be a variety of things. It could be bullying or harassment, it could be sexual harassment, it could be workplace violence. It could be issues around performance management, the sort of things that would give rise to, potentially give rise to harm.
Of a psychological kind.
Of a psychological kind.
And this document, I'm not sure that I'm reading it correctly, but there's a list on page 20 and 21 of specific types of WHS concerns. And the first and it's at about the middle point of that page. Do you see that there, Ms. Weston? The first is bullying and harassment / psychosocial. And I can't see any others that are psychosocial, although there's a catch-all over the top of page 21, all other concerns, complaints and requests. Is this in effect a template for how records are supposed to be kept by staff on the help desk who receive information which
Yes.
should be described as a WHS concern, and how they're to categorise it?
Yes, that looks like that.
Okay. Now, I want to go to a document at item 35 of the tender bundle. Could I just ask before I do, within the regulatory operation group, sometimes described as ROG, I believe, is that right?
It's an acronym and we call them ROG from time to time, yes.
ROG, thank you. And inside that group, is there a team called R&A?
Yes, that's correct. Research and analysis team.
Oh, research and analysis, not risk.
Oh, I beg your pardon, risk and analysis team.
Thank
Sorry.
you. Okay.
Beg your pardon.
And do they produce intelligence reports for Comcare?
Yes.
Yep. And there are a couple of those in the tender bundle. One of them is, I think, of concern to the Commonwealth, and we'll deal with that when we come to it. This first one, I don't believe, is of concern to the Commonwealth, but we'll see. It's item 35 in the tender list, and it's COM stop 0001 stop 0002 stop 0693 _R. So it's a version that's redacted for publication to take out some content that was of concern to Comcare, I believe. And it's, pardon me for a minute. It's an R&A intelligence report, should be coming up soon, entitled Regional Engagement Plans, National and Regional Overviews, March 2021. And Ms Weston, could you just describe for the commissioners at a high level what the regional engagement plans are? What's the significance of the reference to regional engagement there?
So regional in our organisation is largely state. It relates to each state. And so these plans look at, these overviews look at what's happening in our jurisdiction, including on a state-by-state basis. And, yeah.
Thank you. And there's also an overview across the entire nation by the looks of it. Is that?
Yeah.
Yep. And could we go to page 4, which is 0696, please, operator? And we'll just look at paragraph 11, and there's also a graph under paragraph 11. Now, paragraph 11 reports, this is as at March 2021, but I think it's referable to information up to the end of the preceding financial year.
It's like to 31 December 20.
Pardon me,
Yeah.
the previous calendar year, end of the previous calendar year. Thank you. And it says, that if we look at the graph first, there's a category called mental stress, and these are notifiable incidents that have been reported to Comcare, aren't they, Ms Weston?
That's what the heading
So
says, yeah.
just harking back to the point you made in paragraph 29 of your statement about the limitations on the kinds of outcomes that fall within the obligation to be reported as a notifiable incident. If a mental stress incident has been reported as a notifiable incident, it's likely to have had one of those pretty proximate physical outcomes resulting in medical attention for an injury, hospitalisation and so forth. Would you agree with that?
Or a death.
Or a death, indeed. And it's not going to have picked up workplace harassment, psychological harm falling short of those very serious physical outcomes. That's right, isn't it?
That's correct.
And what we see here in paragraph 11 is that 33 of the incidents classified as mental stress, and this is over a period of some years, I beg your pardon, 18
months.
18 months. I'm sorry, not some years, only 18 months. 33 of the incidents classified as mental stress were attributed to suicide or attempted suicide. And so well over half of those incidents are actually so serious that they are suicides or attempted suicides. And I suppose the point, perhaps it's a pretty trite point, but would you agree that this suggests that there needs to be a far broader form of notification before things get to the point of there having to be a hospitalisation or a serious physical outcome, or even worse, an attempted suicide, or even worse than that, a suicide before becoming a notifiable incident? Comcare needs to be notified of incidents of lesser severity so that it can take appropriate steps and understand risks.
Well, prevention and early intervention is critical.
And do these figures to you demonstrate that there's a problem with the notifiable with the limited scope of the notifiable incident reporting obligation?
We've made submissions to that effect.
Yep. Now, incidentally, it also notes in that paragraph that DoD military, and then there's a reference to another document, which is a document that the Commonwealth are thinking about at the moment. I won't display it straight away, at least. DoD military reported 13 suicides or attempted suicides amongst those figures, I assume. And
DoD being the ADF in this instance.
DoD military means the ADF, does it? Thank you. So amongst that group of 33, 13 of them are from the ADF.
That's correct.
Now, if there were if there was an obligation to report on incidents of psychosocial injury, psychological harm arising from some of those factors that you identified, would you have a reasonable expectation that Comcare would be in a better position to understand the risks in the workplace systems of the PCBUs making those reports?
Well, we currently have 10 years of reporting of largely physical injury, although some of the mental injury. It would be good to have equivalent of the psychosocial injuries so that you can actually see what's happening.
Yep. And could that involve what, for example, figures on people taking leave in circumstances where they're claiming to be under stress, for example? Would that be useful information?
These issues are being considered by Safe Work Australia at the moment about what's serious enough to go into those incident notifications. But we should be getting certainly a lot more, at least the serious ones, than would be good to have visibility of those serious ones at least, going forward.
Okay. Can I ask you now about what Safe Work Australia is considering in the context in which that's arisen? You've explained this in paragraphs 177 to 85 of your statement by reference to a review by Marie Boland. Final report was in December 2018. I'll ask the operator to display the final report first, and then I'll ask you about Comcare's position on the issues raised in Ms Boland's report and in the review leading to the report. COM stop 0001, stop 0002, stop 0793. This is tender list document 36. And was Ms Boland the independent reviewer in the first review since the commencement of the national model WHS legislation?
I don't know whether it's the first review. There may have been some other reviews along the way. I understand she was independent.
Thank you. And she has a number of recommendations in fact 34, about the WHS framework. I'll just ask that the operator take us to the second page of Ms Boland's letter of transmission of the report to Safe Work Australia. That's on page 0798. And she says there, just below the middle of the page, overall I'm making 34 recommendations. And then she says something about how many of them are technical. And then she says, others suggest areas for further analysis, for example, the incident notification provisions. Some anticipate long-term projects, for example, initiating an industry-focused review of the model WHS regulations and model codes. Others warrant immediate consideration. That's what Ms Boland says about this very topic we've just been describing. Others warrant immediate consideration, for example, the making of model WHS regulations dealing with psychosocial health. And we just go to a little, I'm sorry, there's not much of a question in there for you, Ms Weston, but I mean, this is all consistent with the understanding you've set forth in your statement, isn't it?
Correct.
And then we go to page 0800, and in the middle of that page, Ms Boland records a view, a consistent view. She says, the express reference to psychosocial health in, beg your pardon, I'll start again. The express reference to psychological health in the Model WHS Act, so that's picking up Section 4, the definition of health in the WHS Act, for example, is that right? Is that your understanding?
Yes. I do understand.
That was overwhelmingly accepted, but there was a consistent view among those consulted that psychological health is neglected in the second and third tiers of the Model WHS laws, that is the Model WHS regulations and Model codes. To address this, I recommend the development of additional regulations on how to identify psychosocial risks in the workplace and the appropriate control measures to manage those risks. And is it that matter that Safe Work Australia is currently considering, as you mentioned a short time ago?
So the WHS ministers came to a position on the recommendations, and Safe Work Australia is working their way through those. There was a decision regulation impact statement in between that, and the ministers looked at that decision regulation impact statement in helping form their decision on those recommendations. So there are a number of recommendations that are being considered by Safe Work Australia, including psychological risks in the workplace and including notification provisions.
Okay, and recommendation 2 is probably the key recommendation in this respect. It's recorded at page 0805 and it's titled Make Regulations Dealing with Psychological Health, and it's very short. It's amend the model WHS regulations to deal with how to identify the psychological risks associated with psychological injury. Amend the model WHS regulations to deal with how to identify the psychosocial risks associated with psychological injury and the appropriate control measures to manage those risks. And there's also a follow-up recommendation which is worth noting, which is recommendation 20. Yes, thank you. Incident notification. And that's on page 0897. It's titled Review Incident Notification Provisions. And the text is Review Incident Notification Provisions in the Model WHS Act to ensure they meet the intention outlined in the 2008 National Review, that they provide for a notification trigger for psychological injuries and that they capture relevant incidents, injuries and illnesses that are emerging from new work practices, industries and work arrangements. And in the text, there's a link back. In the text of Ms Boland's report, there's a link made between those two topics. Isn't there, Ms Weston?
So there is a review underway to meet that recommendation in relation to incident notification provisions.
Yep.
And I think it does also refer, as I need to check about ensuring visibility for regulators of psychological incidents, but I would need to check that.
Yep. And look, there's a lot of great value in what Ms Boland says, and I don't have time to go to all of it, but can I just mention one aspect at the top of page 34, which struck me as very insightful, and I wonder whether it is consistent with your experience as CEO of Comcare. Ms Boland says at the top of page 34, 0827 that is, to date, she says, where there has been a focus on psychological health as a WHS issue, it has tended to be linked to widely recognised and acknowledged psychosocial hazards such as bullying and harassment. However, this has too often led to the individualisation of those complaints, their diversion into grievance processes, and the removal of the original basis for the complaint from any assessment of the broader WHS organisational safety culture. Does that resonate with you, Ms Weston, that point that Ms Boland's making?
I think that there has been a move. The Respect at Work report has moved discussion about psychosocial hazards into the sexual harassment space as well. And what I am seeing now is people looking at not just bullying and harassment, although it is a significant issue, but also sexual harassment and some of those other psychosocial hazards that I mentioned earlier, such as violence in the workplace.
Do you agree that rather than just looking at incidents of bullying and harassment as a matter of individual complaint, it's necessary to take a safe work systems perspective on how the circumstances have arisen in which those forms of misconduct have taken place?
I think that's part of the duty of a PCBU.
Yep. Now, I'll just take you to, a couple of other documents of note. I don't think we've got time to go to Comcare's original submission prior to Ms Boland's report, but that is in the tender bundle. That's COM 0001 0002 0296, but we won't go to it. That was in May 2018.
There was also a submission to the decision regulation impact statement.
Perhaps we should go to that because that's the most recent word Comcare's published on these matters. Is that right?
Mr. Gray, we also made a submission to the the Parliamentary Workplace review that Commissioner Jenkins undertook recently. And in our submission to that review, we also noted similar concerns about access to these psychological incidents, and that we weren't having the visibility of those in the parliamentary workplace as well.
Thank you. I don't have that to hand, but perhaps we will go to your 7 August 2019 Comcare submission on consultation regulation impact statement relating to Ms Boland's recommendations. That's tender list item 5, COM stop 0001 stop 0002 stop 0283. Please, operator. Now, you mentioned in this submission, when addressing recommendation 2, that in fact it's quite a complex matter to get this right, to get the regulations at the sufficient level of detail to be useful without making some sort of, in effect, making an error in the way the regulations might operate. And you say at paragraph, I beg your pardon, on page 2, that in effect, because psychological health is such an extremely complex matter, it requires careful consideration to get this question right. This is at page 2 at about 2/3 of the way down the page. And you say, this is going to make prescribing regulations difficult. Has Comcare actually proposed any detailed content for such regulations, or is Comcare in effect limiting itself to these more general remarks?
So Safe Work Australia is a tripartite arrangement with government, the unions and employers. And the seat at the table for the Commonwealth is the department, and we are supporting the department in that role. And I am confident that we are looking at the work that's emerging from the Safe Work Australia processes to assist.
So in that forum, there might be more detailed work going on that Comcare has a hand in.
Beg your pardon? So in that forum?
In that forum, there's more detailed work going on in designing the regulations that Comcare has a hand in.
So we have a policy team that are working with the portfolio department to help with the work that's underway on both, for instance, the where they're heading with the code of conduct and with the incident notification.
Over the page, at the top of page 3, Comcare also makes the submission that there will be resourcing implications. And do you want to just briefly outline what would be needed to get Comcare in the best position to be able to address reports of psychological injury and psychosocial risks?
So while our inspectorate are currently looking at psychological injury from time to time, we have established our own psychosocial risk regulation team. So we have already recognised that there will be additional work coming out of both these reforms emanating from the Bolton view, but also we're trying to find pathways, as I said before, to get information, to check in on how PCBUs in our jurisdiction are going. And that team has already started its work in this area. So, yes, we've already taken some steps to resource this work.
And so the benefits of broader notifications would entail the inspectorate function being able to understand, in a broader range of cases and hopefully before things get to the point of attempted suicides or even suicides, what the risks are that are generating psychological harm. Is that a fair summary?
Yes, what we would be trying to do is look, for instance, compare how organisations are going against the draft code and also an international standard that's available to help with the management of workplace health and safety, psychological things in the workplace. And so what we would be hoping to do is work with our jurisdiction. We're quite fortunate in our jurisdiction that we can identify all the PCBUs, around 220 or so of those, whereas in other jurisdictions they may have thousands of businesses that they need to engage with. So in doing this, what we would be trying to do is make sure that they have identified the psychological hazards, that they are risk assessing against that, they are putting controls in place, they are talking to staff, they are reviewing whether those things are working in the psychological space. So that's the forward proactive work that this new team is planning to undertake.
And Ms. Weston, because of that complexity that's mentioned in Comcare's submission on regulatory impact, it's probably fair to say that it is probably more challenging to try to identify psychosocial risks in your work systems than it is physical risks. But nevertheless, it can be done. Is that a fair summary?
Well, I think, yes, it can be done. There are tools now available to help regulators, and we will be using those to help the people in our jurisdiction.
Can we just go to one of those to demonstrate that a broader, in effect, information base or data set on psychosocial risks will be of utility to you and hopefully utility to the workplaces of the PCBUs, because there are tools available that can help you and them assess psychosocial risk. And the example you give is called a lead indicator mentoring program, I believe, on a tool called the Psychosocial Safety Climate. Is that right?
Yes, so...
We'll bring that up. Yep.
So
that's 10 that 29.
That might be a control that's deemed relevant in the assessment of controls to risk manage the hazard. So let's just say that's deemed to be the case.
I'll just bring the document up and I'll get you to explain it to the commissioners if you wouldn't mind, and to me. COM stop 0001 stop 0002 stop 01 big pardon stop 1030 0001 0002 1030. Thank you, operator. And I don't know whether I've given a fair description of what this document is actually describing. I'll just ask you, Ms. Weston, what is it? Is it relevant to the topic we were just discussing?
So this is a tool that allows groups of people to assess what the safety climate is in the team they're working in. And it uses a psychosocial safety climate, I can't remember the actual word, let's just say tool, and it's over a period of time, and it looks at lead indicators, things, for example, as I understand it, sick leave and things like that. And it then allows the group to work out how they can work better as a team. The research from the University of South Australia is now published, as I understand, this particular project, and looks like it has some merit in being forward-leaning in terms of whether there are some things appearing in the workplace that could benefit from the process, which is to look at the barriers and work out ways forward.
Another point you've mentioned. So this would be conceptually in the preventative space.
Yes.
Create a good climate that's psychologically safe,
Yes.
and this helps you to determine how you're going in that endeavour. Is that a fair
Correct.
summary? Thank you. And you've also mentioned a couple of other times when I was asking you about the utility of broadening the database and the notification obligation, you've said words to the effect, well, it's important to intervene early. And Comcare's done quite a bit of work in the early intervention space when it comes to various forms of injury, but in particular, well-being and psychological health as well. Is that right? You've referred to quite a few initiatives over time on this topic. I might just quickly display those and you can explain them to the commissioners.
So we have a priority in the organisation for prevention and early intervention across the scheme. We have tried to showcase some examples that are useful in the early intervention space. A lot of the jurisdiction are already thinking that early intervention is really valuable and have resources available to help. But some of the early intervention programs do look promising for people who are looking for controls in this area. And so we have reviewed those formally, evaluated them. We have put cheat sheets and other help on our website. We remain available to help people to implement those programs themselves. More recently, we're in consultation for a new prevention strategy as well, because obviously further forward than the early intervention is critical for both individual resilience and organisational resilience.
Thank you. And back in 2014, there's a document at Tender Bundle 21, COM stop 0001 stop 0002 stop 0473, and that's, I think, it's entitled Early Intervention Report, and it's effectively a sort of a literature review, is it? As opposed to a fresh piece of empirical work at that point in time?
I would need to have a look into that, but I would expect that we do a lot of literature reviews to see where to point to in the work we're doing. But look, that I wasn't around at that time, so I would probably need to be more careful in my response on that.
That's fine. It probably goes beyond that. I think I've been a little bit limited in my description of it. It's also, by the looks of it, it involves obtaining information on the views of premium paying agencies. So this is presumably in Comcare's Workers' Compensation Scheme Administration.
It is relevant for that. It is relevant for that. And that Act has been going since 1988. So I think that one of the things in that space is that, you certainly don't want to be waiting until you're wanting to lodge a claim. You want to be, if someone has an injury, you want to be getting to it in the workplace early so that they can recover early and return to work.
Yeah, and
which is important for their well-being.
I do beg Comcare's pardon. In addition to the literature review, there was indeed the obtaining of information from premium paying agencies in various ways, including interview and survey.
Thank you.
Now, a little later in the chronology here, there seems to have been a service pilot on early intervention, which was evaluated by Deloitte. And I think that is during your tenure as CEO. Do you recall that project?
Yes, I do.
And that showed some, well, quite significant efficacy of early intervention in relation to physical injury.
Correct.
And of course, physical injury, as noted in this evaluation, can have consequences for mental health and well-being more generally. So that's a very important matter, isn't it?
Secondary psychological injury is a feature of some people's physical injury.
And also, when it comes to simply psychological harm independent of physical injury, there are also noticeable benefits to early intervention, although not as they weren't quite as clear as in respect to the first category of clients.
So what was available to people in that program, which is effectively a nurse triage approach, was that a person rang the nurse triage who might be able to give them some self-help, but also it was available for treatments at a GP, at a psychologist and at a physiotherapist that we had made available so they actually could access them. Sometimes access to some of these services is an issue. But if the person was very unwell, 000 was available. And the program, as showcased in those results, was quite effective. Had some very good recovery for the people who were injured. And we have prepared, I'm calling cheat sheets, but a guide and an evaluation mechanism, I think, available for people on our website.
I'm not sure if this is the document you have in mind, but it's COM stop 0001, stop 0002, stop 0527. It's a Comcare document entitled Early Intervention Service Pilot with key findings and recommendations in the form of a fact sheet with schematics.
That's what I'm thinking of.
Yeah.
I think there were two though, Mr. Gray. There was some other one with an evaluation methodology, maybe?
Yes, there was a Deloitte evaluation executive summary.
I had thought there was another document around how you might go about putting that in place or something equivalent. But if we don't have that, I'll certainly provide it to you.
Thank you. We may have simply omitted it from the list, and if so, apologies.
It's okay. I could be another program I'm thinking of, but I will check that for you.
Thank you. If we look at this, thank you, operator. There's the Deloitte evaluation. We'll go back to the Comcare fact sheet. I take it that the Deloitte evaluation and the Comcare fact sheet relate to the same early intervention service pilot.
That is correct.
Yep. And if we go to page 2, please, operator, that's 0528. For the improved outcome for psychological injuries over presumably the control was 10 to 30% lower likelihood of developing a chronic condition. Does that accord with your recollection of the outcome for psychological
injury? That's right. I've read that outcome. Yep.
And it was 50 in the order of 50% for physical injury.
Correct.
Now, I'll just go to another topic, and this is where things might get a little more difficult, and our friends with Commonwealth may wish to be heard now.
Can I just have a quick word with Mr. Gray? I might be able to shorten some of this.
Yes. Do you want it stood down?
I only need a minute. I can either stand it down or wander over.
Wander over, I think.
We largely have agreement, Commissioners.
Good.
But Mr. Fordham may need to still be heard.
Yes, I understand that.
We'll just see how we go. Now, I'm not going to display any minutes of this body, but I'm just going to ask you about it at a general level. I've already mentioned it. It's the Defence/Comcare Liaison Forum. And I'm not going to display this document either. I'm just going to mention its existence. There's a communication protocol that's been in place between Defence and Comcare in different forms, at least in 2 different forms on my analysis of the documentation. Is that
I'm
that
familiar
right,
with at
Ms.
least
Weston?
one.
Well, there's a current one dated in around 2019. And one aspect of that is that it provides for twice a year there to be a liaison forum between Defence and Comcare. I want to ask you about, in effect, that body and its function at a general level, and any other institutional arrangements, and you mentioned another one, the advisory board, in your statement, between Defence and Comcare, which are really designed or intended to address any systemic work health safety issues that seem to be arising on the data, any issues on the horizon generally, any preventative steps and suggestions for improved systems. So starting with the liaison forum, is that the highest level of consultation for those purposes between Defence and Comcare, Ms. Weston?
So at the higher level, I meet with, and sometimes with one of the general managers, I meet with the leadership from time to time. Then
you meet with leadership?
Leadership in the Defence and at times the ADF.
And at what level?
Oh, at the Secretary and Head of the ADF.
Chief of Defence Force?
Yep. Yeah, sorry, it's just I'm being conscious of using the correct title.
Thank you. So, well, that's certainly then the highest level of engagement. Is the liaison forum that happens twice a year, in effect, the second tier of engagement?
So I think in between that there is a Defence Workplace Health and Safety Board that my general manager colleague is an observer to, but can, provide input to through an engagement with the people organising that group. And then there's a Defence Liaison Forum as a mechanism at an operational level to share information, encourage Defence on workplace health and safety issues, and to hear from them on initiatives that they have.
Thank you. And you pardon me for a minute. You mentioned that board you just mentioned. Is that also described as an advisory board?
I don't recall that, Mr. Gray. I would need to check that for you.
Pardon me for a moment.
I could have that title not right either. So if I'm very happy to confirm that for you.
Yep. Well, perhaps Ms. Bridget, if you could check for the title of that board, and we'll come back to that. Thank you. The issue, I'll just ask at a general level without displaying the minutes, but there's a document in the tender bundle which I'm agreeing not to display publicly. It's at item 11. It's minutes of a liaison forum meeting in 2015. And it included as a topic of discussion this topic you've been discussing in your evidence in response to questions from me about difficulties in reporting injuries of a psychological or psychosocial character.
Okay.
Is that right?
I didn't attend, but the minutes if the minutes record that, I would say that that is what happened.
Yep. And there was an action item for Comcare and Defence to, in effect, have discussions trying to iron out uncertainties in the limits of the limits of the notification obligation. Is that?
I would have thought that the helping to explain how the law operated would be understandable thing to do. Yep.
Yeah. And was that an action item from back in 2015, as you understand
I'd need to
what
check.
occurred at that meeting?
I
Okay.
need to check.
And it isn't clear where that inquiry ended up on my reading of the documentation. So perhaps if we could ask you to also
Very
see
happy
whether
to
the
check
records
that.
of Comcare show
Yes.
where that went to. Again, I won't display the documents, but it seems there was an intervening meeting or meetings that might have discussed this topic, including one in August 2016, and some more action item, or another action item in August 2016 relating to trying to clarify the notification obligation. And have you
So I'm
been
familiar-
over those records?
I've had a look. I think there was a letter that helped describe how some of the provisions operated that I've reviewed. So I think if that's what was an outcome, then
That's right. I've agreed not to display that letter, but that's in April 2018, responding to the action item from the August 2016 liaison forum meeting.
it
And
could
it
be.
it doesn't seem to go to psychosocial harms and notification of psychosocial harms. The closest it gets is perhaps a question about whether the hospitalisation limb of the definition of what must be notified would be met if a person receives medical attention on base.
That's one of the topics I think that is in that letter.
All right. Just moving to a more general level about defence and thinking about this topic of notification of psychological harms or psychological injuries, and without trying to prejudge where Safe Work Australia might go on that and what the regulations might actually say. At a general level, when you consider service life in the ADF and the fact that it's really commonly the case that a person in the permanent forces is either living on base or living nearby a base and is almost connected with service life 24/7. Are there particular challenges that you see in trying to work out where the nexus might begin and end with the workplace and the requirement that an incident be an incident arising out of the business or enterprise of the PCBU?
I can understand what you're saying about there being issues like that. It's interesting at the moment that with the pandemic there is some issue as well with blurring of work and family life, and I think there's some research that's underway in these sort of areas, so which might be helpful in looking at that particular problem. But in terms of seeing workplace incidents that are in that space, other than perhaps hospitalisation for something that's happened, you know, on the that we've discussed, we wouldn't have the visibility of that, any of the psychological things at this point, other than perhaps through our psychosocial inspectorate work that is coming up.
Would Would I be right to suggest that,
Excuse me, Mr Gray, or
Yes.
other notifications that we might receive that don't fall into that category? So WHS concerns or things like
WHS
that.
concerns or your own analysis of
That's right.
media and
Yeah, that's
so
right.
forth?
Yes.
Would I be right if I suggested that, given the nature of ADF service life, it's better to err on the side of assuming that there is a nexus arising out of the conduct of the enterprise in question, where there is, say, for example, a suicide attempt or self-harm of an ADF member, even if that happens off base and outside working hours because of the nature of ADF service life? Is that a reasonable assertion?
I object to that. There'll be a blurring here between the expertise of the witness and perhaps psychiatric evidence.
Mr. Gray?
Well, I think I'd be in difficulty if
Are you talking about
the Evidence Act applied.
Are you talking about how they should approach it as an organisation,
Yeah,
operationally, rather than what the legal
yeah. As a
conclusion
regulator,
may be?
with a regulator's objectives of trying to understand workplace risks, rather than as any
A
purported
court
expert.
determining whether or not this fell within the cover, for example.
Yeah, and not attempting to apply a psychiatric lens, simply as a matter of a regulator's expertise. I admit I'd be in difficulty if the Evidence Act applied, but I think the answer from a regulator's perspective should have at least some probative value for you commissioners.
On that basis, Mr. Fordham, do you want to press it?
If the question is put on the basis of what a regulator does across any number of industries, including defence, where people live in particular circumstances, then I don't object to it.
And you can imagine it like a mining operation on site.
Exactly.
Might be a bit similar.
Correct.
Right. I'll allow the question.
Thank you.
For Ms Weston's benefit, Commissioners, could the question be restated?
Yeah, thank you. I'll restate it and I'll refine it, in fact, in line with Mr. Fordham's suggestion, which I understand to be the form in which you'd prefer it to be put, Commissioner.
Thank you.
So, Ms Weston, just drawing on your experience as a regulator, WHS regulator, and not attempting to apply any psychological or psychiatric expertise at all, as a matter of worthwhile practice from a regulator's perspective, would it be appropriate for an assumption to be made that in the context of a workplace such as the ADF, where there is a connection with service life, even outside strict working hours, if there is, say, a suicide attempt, should an assumption be made that it arises out of the conduct of the enterprise concerned and therefore is notifiable?
Perhaps I might just alert you to our procedure for fatalities generally, and where there's a potential self-harm, we have a list of things that we ask our inspectors to consider, which includes whether there was any issues with the workplace, home life, those sort of things. There's a series. And so that's what we are asking our inspectors to have a look at when they come across a potential self-harm incident.
And thank you, but I don't think that is an answer to my question about your
So
opinion.
can you repeat that question then?
So as a regulator, and not purporting to be a psychiatrist or
No,
psychologist,
I'm not.
and given the nature of ADF service life, should an assumption be made that if somebody, say, attempts to take their own life, even if it's outside strict working hours, should an assumption be made for incident notification purposes that arises out of the conduct of the enterprise of the ADF?
lots of challenges there in relation to what the Act says, for one thing, and then every one of those is very different. And would I think that it should necessarily... I think what I would say is that there is definitely a gap in that information in general, and I think that that there is a place to see how we can collect that important information. So whether it's in the way you suggest or whether some other way, but nonetheless there's sort of a piece missing in looking at workplaces, where there might be one of the factors may be work, but one of the factors may be a number of other things. So it's a very difficult area, but nonetheless, I think my statement says that there's this gap and potentially a need to have a look at how we can gather that important information.
Yes. Now the board in question that I'd forgotten the name of is the Defence Senior Work Health and Safety Advisory Board.
Okay, thank you.
Where does that fit into these institutional arrangements?
If it's the one I'm thinking that my General Manager of Regulatory Operations is an observer to, I think that sits above the level of the operational Defence liaison arrangements.
Thank you. And is that the same as the board you mentioned to the Royal Commissioners a short time ago?
When I was saying that there's that senior level and then the WHS board,
Yep.
yes, I think that's the same board.
It's the same board. Thank you. Now, there's also been a meeting of a body described as a round table, and I'm going to put this document up on the screens, Tender List 31. I believe it's consistent with the agreement that's been struck.
Will you permit me just to wander over?
Oh, perhaps I got that wrong. All right. Well, I'm going to seek to display the document. Mr. Fordham may have something to say. It's a roundtable described as Department of Defence Roundtable Mental Health Preventions Program held on the 9th of February this year.
Yes.
And you attended that,
I did.
Ms. Weston. And it's COM/0001/0002/0593 _R. It's redacted for publication. The names of the attendees, for example, are redacted. And this document records...
I do have an objection. It's proposed that particular action items be displayed. I have instructions on some of those, and on those that I don't have instructions on, it'll be a short argument.
Right.
Rather than putting up the whole document.
Okay.
Another solution is to just, and I know it's slightly unsatisfactory, but to put it up so that you commissioners and the witness can see it, if it's difficult to display individual bits.
That might be preferable if that's possible.
All right. Well, let's display it just for the witness and the commissioners then, please, operator. And I'll just limit myself to reading from the action items and the explanation of the action items. I'll start with on page 0594 for the commissioners and the witness. There's a heading Defence Mental Health Strategy, and arising out of discussion at the roundtable on that matter, there was agreement, was there, that Comcare and Defence would further discuss the mental health strategy evaluation approach, including how it is applied to research?
So this round table was an opportunity for us to look at the programs in place in Defence, and we did talk about we did talk about the programs that we had undertaken, some of them being those showcase items we talked about earlier, and how we evaluated those. And I think that discussion was therefore about sharing information on how evaluations can happen.
And is that, when you say evaluations, is this evaluations by Comcare of how Defence is performing on mental health strategies?
More about just describing strategies, and then Defence could potentially consider those, or do, they have within their programs, you can see an evaluation approach, and it's just helping to articulate other or potential ways to evaluate the programs they have.
All right. And what are the programs? Can I ask, what are the programs?
I don't have those instructions. I wasn't asked to get them.
All right, well, I'll leave that for a minute. Under the next heading, Initiatives, Partnerships and Research, still on page 0594 for the Commissioners and the witness, there are examples perhaps of some of the programs, and you've referred to some of them in your statement. One of them is that Comcare, and this is action item 3, Comcare is to share...
Can I just raise an issue? I don't have instructions on this particular paragraph, but Commissioner, I would invite you to rule on it.
You'd like me to rule on
I'm objecting to it because I don't have instructions yet in relation to it.
So you don't wish me to refer to the paragraph, the content of the paragraph under Initiatives, Partnerships and Research?
No, I don't have those instructions. And for the rest of the document, 1 and 2 I have instructions on. The balance I do not. But I have no instructions either way, so I'm not intending to put an argument should you wish to rule on 3 or 4.
Can you work around that in the meantime?
Well, I was going to ask a little bit about the initiatives described by name under that heading, so that's difficult.
I do have the instructions in relation to 40, so if you'd like to go to that document, I'll see if I can push a bit harder.
All right.
Maybe that's what I'm trying to say.
Okay. We'll
Are these public immunity grounds that you may be seeking instructions on? Public interest immunity?
Possibly, I'm not entirely sure.
Okay.
All right. Well,
But no, I don't put it any higher than that. I don't want to make a submission that I'm not sure about.
Sure.
I'll leave action items 3, 4 and 5 for the time being.
Can I just suggest to my friend, are you suggesting that the words below action item 2 that commence with those commence with the intersection? Because I'm not sure that, I think the words below that refer to action item 2 as opposed to action item 3. I think you might.
Yeah, I was going to read from the paragraph under Initiatives, Partnerships and Research.
My understanding, looking at the document, is that is part of action item 2, which I don't object to.
Okay. Oh, that means I'll ask about them then.
I'm sorry to be difficult.
Yep. So what is the ADF Centre for Mental Health and the Head Strength app and the Wellness Action through Checking Health project? Was that was that one of the mental health strategy evaluation approaches?
So they are programs that a defence is has management of. And I, just from reading those minutes, there was some correlation in the results that were talked through with one of the programs that we provide that Defence is a part of.
And that's Comcare's new access coaching service?
Correct.
And how widespread are they 3 different projects? ADF Centre for Mental Health, is that one, and then Head Strength app is another, and then Watch project is a third?
What was the question again, sorry?
Are there 3 different projects, or are they all one project?
I think there are 3 different projects, but I just honestly can't recall at the moment.
Okay. All right. And do you recall whether any particular proposals were made to evaluate how those projects are going, or whether, if they're one project, how that project is going?
So in the presentations we received, there was clearly an evaluation approach highlighted, and we are interested in how programs are evaluated, particularly, as I've mentioned before, where they're going to be used as part of risk management strategies. This isn't just a defence issue, it actually is more broadly an issue of people putting in place risk management to manage psychological hazards, and somewhere else having a wellbeing strategy. And if that wellbeing strategy is considered part of the control, then under the WHS Act, people need to make sure that those controls are assessed to see if they're working. That's why the evaluation piece is important. But this bringing into the WHS space of those programs, if they're controls, is something of important consideration for us as WHS regulators.
Okay, thank you.
Can I invite my friend to continue with this document?
Yes.
In the way that you are going to the paragraphs you mentioned?
All right.
I have those instructions.
Thank you. So if we then go to the next page, page 0595, there's a major heading, Comcare Update, Insights and Area of Focus. And then there's a subheading, New Psychosocial Inspectorate and Approach. And we won't display it for the public, but the commissioners can see, and you can see, Ms Weston, that this is a record of Comcare advising on reforms underway to address, in effect, that aspect of the Boland review that you've already explained to the commissioners, and also picking up respect at work on sexual harassment, and that you're introducing a new psychosocial inspectorate and approach.
So I think when we talked about resourcing, I mentioned this new inspectorate. Yes.
Yep. And then there was discussion, was there, about how Comcare and Defence should consult and liaise to make that inspectorate as effective as it can be in relation to Defence. Is that a fair summary?
Can you just repeat what you said? Sorry, I was trying to read it at the same time.
The discussion that ensued, was that about the interaction between Comcare's new psychosocial inspectorate and Defence, and how Defence could in a consultative way, make that inspectorate's work effective or as easy as it can be by providing certain information.
Yes, so what I just mentioned about that interaction between the programs to support wellbeing and the WHS strategy is, I think, where that's going.
And some of the information in question under action item 4 was to be the provision of action plans that operationalise its mental health strategic objectives, and the Joint Health Command will be the point of contact for this work.
Yep.
That's action item 4.
Yes.
And what's the time frame for that action item?
So I don't think there was a time frame per se, but the psychosocial inspectorate has already been engaging with Defence, and so I think some of it's already sort of happening in a way, but I would have to check the progress of all of those action items. Some of them I know have been met or in the process of being met, and that's a role for my executive officer, so we'll check up on that.
We can follow up afterwards.
Yeah.
Thank you very much. And finally, that action item 5 was that Comcare will share the Defence presentation with its inspectorate. Is that the presentation of those initiatives that you've already been discussing?
Yes, so there was a presentation covering the work being done on wellbeing and related topics.
Thank you. There's a important document, which is document 40. One of the topics, this is another risk and analysis intelligence report. One of the topics in it relates to a disparity between reported incidents of, reported notifiable incidents to Comcare that are in the nature of suicides in the ADF on the one hand, and similar information as reported by the Australian Institute of Health and Welfare on the other. Are you familiar with that
Yes.
issue of the disparity between the two? And let's just demonstrate the point, if I may. In your statement at page 10 and then over the page to page 11, you have a table in response to a question the Royal Commission asked you. This is back to Ms Weston's statement, please, operator. At page 10, the foot of the page, you've set out a table, you've included a table setting out a number of notifiable incidents relevant to categories that we asked you about in question 5, and the table is then helpfully captioned so that you can see what the various numbers refer to. The table's over the page on page 11. This can be displayed for the public, please, operator. In 2015, for example, these are deaths reported by Defence of serving members of Defence. Is that right?
Look at mine.
At the top of page 11 of your statement.
So it's ADF.
ADF, thank you. So in 2015, there were 5 deaths by suicide. And there's also other columns, and the middle column is psychological illness or injury. But if we just focus on the column for the most extreme form of harm that we're concerned with in 5A, death by suicide, we've got 5 deaths in 2015, and then for each calendar year that follows, the number as notified to Comcare of deaths of serving members of the ADF by suicide in the respective year. And then we noticed that the AIHW figures are higher, and they're available in an exhibit already in the Royal Commission, which is at tender list item 43, and they're quite significantly higher. In fact, this disparity has already been noticed by the Risk and Analysis Intelligence Officer, who prepared a report which is at tender list item 40. So I think it's probably best just to go straight to that document to ask you about this point. It's COM stop 0001/0002 stop 0676_R. And by agreement with the Commonwealth, I'm only going to certain paragraphs of this document, Commissioners. I'm not going to display it to the public generally, but we can display certain paragraphs.
You can display the paragraphs to us and the witness, or to
And to the
everybody?
public,
And to the public.
by
Thanks.
agreement. Sorry. Now, just stepping through this document, the first point to note is the purpose
Can I
of
just
paragraph
raise a
3.
technical issue? I'm sorry. One of the difficulties is going to be that to go to certain paragraphs, if you can isolate that paragraph and put it up, there's no problem. It's when we start displaying things either side of it, I just don't have those instructions.
Yes, we'll go straight to the paragraphs and only the paragraphs. So we'll go to paragraph 3 on page 1, please, operator.
Thank you.
And the purpose of this report, which is a February 2021 Risk and Analysis Intelligence report entitled Suicides and Mental Health, Department of Defence. The purpose is described as to address concerns as to whether there has been a potential increase in suicides, attempted suicides, and suicidal ideation within the defence, military and civilian serving members in recent times. And you're familiar with this document,
Yes.
Ms West? Next, on page 2, I'll go to the key findings. Did you ask for this report to be prepared for that purpose, Ms Weston?
I didn't ask, but it would have been one of the people in Comcare.
Yep. And under the key findings, there are 2 significant challenges to wellbeing identified that are current at the time. That's not to say they're the only challenges, but they're 2 at that point in time which are particularly acute according to the author. Is that right?
In the first dot.
And there's an increase in DVA claims processing times. And that's attributed to the COVID-19 pandemic by this officer. And the second challenge is the release and impact of the Brereton report findings. And then in the next dot point, there's a marked increase in suicides, attempted suicides and suicidal ideation as notified to Comcare by Defence, both civilian and military, compared with the previous year. So that's in calendar 2020, is it? Compared with calendar 2019?
I need to confirm that. It would probably, no, I need to confirm that.
Okay.
It's just that the AIHW, I think, is calendar year. So it's just why I'm just a bit cautious there,
All right.
I think.
And there's some more detail about that increase. And then in the second last dot point, the findings say, given there is a portion of suicides, attempted suicides and suicidal ideation occurring whilst workers are on leave, further discussion should be considered relating to whether an incident at work related, whether an incident is work related if a worker is on leave, specifically sick leave, stress leave, or rehabilitation return to work program. Does Comcare have a position on that issue? Has there been consideration of it and a position arrived at on Comcare's part?
So we do have the section 38 of the Act, which will drive what happens here. That will be that the PCBU has the duty to notify, so particularly, let's just say, suicides, because it's death of a person, where they arise out of the work of the business or undertaking. So the primary duty there is to consider whether there's an incident and whether it arises out of the work of the business or undertaking. So all those items around sick leave, stress leave are put into that category.
So there isn't a presumption or an assumption along the lines I was suggesting before that if an incident occurs, that is suicide, attempted suicide or suicidal ideation occurs on sick leave, stress leave or rehabilitation, that the incident is work-related or that arises out of conduct of the enterprise, but it goes into the mix.
That's right. There isn't an assumption. Every case needs to be put through that lens.
All right. I mean, it is difficult, isn't it? Because the notification requirement is to notify Comcare as soon as the PCBU becomes aware of the incident.
Immediately, I think it is.
And there isn't time to conduct a detailed inquiry into what might have been on the mind of the person who has perhaps attempted suicide or had suicidal ideation. And it would be a very complex thing to try to work out precisely what all the factors are that were on that person's mind. Would you agree with that?
So Comcare has an approach where, if in doubt, notify. So that would allow them to go down that path and notify us.
All right. Well, if you take that approach and apply it to a situation where a person's on stress leave or rehabilitation to work, there's at least a doubt as to whether the matter isn't work-related. Would you agree with that?
Well, it will depend on whether the people who are responsible have the knowledge of how the Act operates and are able to turn their mind to it. But these are complicated areas, and this is what the review of the notification provisions should be, looking at closely.
Indeed, and that's noted in the last bullet point that it's noted that matter's under consideration. Can we go to just paragraph 10 on page 0678? Thank you, operator. There's a reference here to an increase in calls for assistance in just a few days to something like double the usual calls of assistance directed to Open Arms. And is this the only source of intelligence you received about this topic? Do you know how long it persisted?
So this would be a situational awareness where they're gathering together information. So I don't know that then it necessarily was updated per se.
Mm. So the sum total of your knowledge that you're currently conscious of on this topic of the increase in calls for assistance to Open Arms following publication, this is following publication of the report known as the Brereton Report, or at least publication of some of its key findings.
So I'm not saying I'm just saying in relation to this document, situational. There obviously, we received other information from Defence that we shared with some of our providers that were supporting Defence people in programs. And I received information from DVA about this particular challenge at the time.
I see.
There will be others as well, but that's just things that I'm aware of as well.
And to the best of your recollection, based on those other sources of information, how long did this situation of elevated calls for assistance directed to Open Arms in the wake of publication of findings of the Brereton report persist?
I don't have that information.
Okay. Do you know if calls remain elevated above general average historical levels
I
in the
don't have
wake
that
of?
information.
No. All right. Now then we go to a graph on page 5. Operator, can we please skip paragraphs 16 to 18 and go straight to the graph on page 5? And this is a graph of, in effect, plotting the number of suicides, attempted suicides and ideation reported as notifiable incidents by Defence from the beginning of 2012 to, in effect, the end of 2020, or just the very beginning of 2021. And there's obviously a spike noted in 2013, and there's a slight elevation, well, a noticeable elevation occurring in 2018 and 19 and 20 as well. Would you agree, Ms Weston?
Yes, and it covers Defence and ATF.
Thank you. This is separated into members of the department as opposed to members of the ADF.
Correct.
And it's members of the ADF who appear in the line which has the spikes I just mentioned. Thank you. Then if we could please go to top of page 7, there's a quote from an inspector's report. I'm not going to refer to the details of the case, but this was a report into one of the notifiable incidents, and it was an attempt at suicide. And just before this quote, at the top of page 7, it's noted that MC activity relating to the matter is now closed. What's MC activity?
So it's an inspection.
Okay.
It stands for monitoring compliance activity.
Thank you. And in the quote in the inspector's report, there's reference to an opinion, in effect, that, and I'm reading from the end of the second line, that Department of Defence should consider that all Defence Force workers, inclusive of those commencing or Defence Force workers on long-term rehabilitation strategies, receive ongoing mandatory education regarding suicide awareness and the management and prevention of substance abuse. I just want to ask you about that in a second. And then there's a further suggestion. Just on that question of substance abuse, take alcohol, excessive alcohol consumption, for example. I think our Royal Commissioners can take it on notice from common sense that alcohol consumption generally occurs after strict working hours. But returning to that topic about the challenges of ADF service life being something that, in effect, merges outside strict working hours and might involve common accommodation arrangements or on-base accommodation arrangements and socialisation after work. Has Comcare considered the role, if any, played by alcohol or other substance abuse in safe work systems issues when it comes to understanding systemic risk of harm from arising out of or in connection with the ADF enterprise?
In around 2012, there was some issues with alcohol abuse, and Comcare's developed a program, 3-phase program that we worked with Defence as well, that had a number of elements such as looking at research, key messaging, and also collaboration effort. And I think that there was, this was a head of Defence's own piece of work around management of alcohol. The Safe Work Australia and Comcare does have some information on alcohol, consideration of alcohol. I think in relation to early intervention programs, in the case of Comcare, on its is part of it as part of its education programs on our website, for instance. And you know, it is something that we can prepare tailored programs, you know, to assist parts of our jurisdiction who may have issues such as this, to help manage. In terms of alcohol, that may be a factor in other things such as vehicle accidents, if there was any. Certainly, that would be something that that the police would test for, say, and it would be something of great concern to us as well as a regulator.
Has Comcare done any work on any nexus that might exist between suicide, suicidal ideation, attempts at suicide as reported to it or as raised in WHS concerns, and substance abuse?
I'm not sure if
in
any
the defence context.
I'm not sure. No, I don't think so. No.
Look, finally, there's a long section at the end of this report, this risk and analysis intelligence report, beginning at the foot of page 10, just under the heading Australian Institute of Health and Welfare Data, paragraphs 40 and 41, and then going over the page and going all the way through to page 12. And in that passage, the author from the RNA unit notes the discrepancy between notifiable incident reports to Comcare and AIHW, Australian Institute of Health and Welfare data on suicides amongst serving ADF members. And paragraph 43, the author notes there's a significant difference in the numbers. Comcare data, for example, shows 24 suicides in the period 2012 to 2018. And there are many more reported by the AIHW. And the author attributes this to the hypothesis that many incidents are not reported to Comcare as they are deemed to be non-work related. Do you agree with that hypothesis? Are there any other explanations that you know of or can think of?
So the key one will be the Section 38 arising out of the need for the incident to arise out of the work of the business or undertaking. There is one thing though that we may have an incident reported where an inspector on review considers that it doesn't meet that Section 38 threshold and may notify that as not notifiable. So they're the two ways.
Thank you. Just going back to your statement, at page 43, you, under the heading question 26, you address a number of aspects of what might be done to improve matters in response to this question. If you've formed any views in the course of your duties as CEO of Comcare that the ADF or the Department of Defence could take additional steps to mitigate the risk of deaths by suicide of members and ex-serving defence members, what are those views? And the first topic you mentioned at the foot of page 43 is the expansion of the notification trigger for psychosocial injury under the heading of the Boland Review. And where that's left at present, at paragraph 182 of your statement on page 44, is that the various jurisdictional ministers who are responsible for WHS have reached agreement on actions in response to the 34 recommendations, and you mentioned that a little earlier in your evidence today.
Yep.
Do you know of any further development since then?
Yes, so there is work going on in the Safe Work, led by Safe Work Australia, with the employer groups, the union groups, and the government to press on with code of conduct and working on the notification provisions. It probably is something that changes regularly as they meet, and we can provide you with an update on that.
All right, thank you. But no estimate as to when any regulations might be available to be considered by Executive Council?
I could find that out for you, but I'm not aware.
Okay, well, we might follow up with you
Yes.
afterwards. Thank you.
Yep.
The second heading is on page 45, and it's under, there's a broad heading of education and training resources and programs. And in effect, you're providing examples of them, but I suppose, are you saying that just continuous improvement in education and training is an additional step that should always be taken? Is that the gist of what you're saying?
So Defence is a big ADF. It's a big and dynamic organisation, and so investment in WHS training and activity is probably very critical in my view. And what I've said in my statement here is the opportunity that these Bowen reforms present to reach to all levels of the organisation, to explain what the new code is going to require of them. The code, actions in accordance with the code become something that can be referred to in courts, and it provides a great opportunity to educate at the same time on these psychological matters that are very important.
Yep, thank you. And the next heading is enhancing manager capability, and you've given the Royal Commissioners some detail about how a project that you're running, are you, within Defence, or you're making available for Defence to run, called the Enhancing Manager Capability Project?
So that's a new program that we have that's available for people. If we could certainly work with Defence to target some particular effort, but I think this is responding to across the jurisdiction issues around managers being able to see or identify that there's mental health issues, support people, help them get back on the road in that early intervention position that you were talking about earlier. That's it's about making sure that the managers have those skills, which
and I think
easy.
I think I made a false assumption about this. You're not saying that you're already working with Defence on this, but you're saying this is something that Defence could consider.
That's what I think I'm saying, yes.
Right. In effect, you're suggesting that they take you up on that. Is that right?
It could be that they have already signed up for this program, some people. I would check that for you.
Okay, thank you. You also, at the end of that passage under a subheading, refer to a psychological risk assessment tool called People at Work. And is that's not like the SAFE psychosocial climate tool? It's more individual, is it?
No, it's in a lot of ways, it deals with the team. So it's a team environment thing. You need 20 people, at least 20 people in the team, and there's a survey, and it works through in quite a simple way the areas where your team needs to improve. And so for groups where there's an identified issue in part of the organisation, it's quite a nice way to work with that group to make their relationships better.
All right. And then you refer to the lead indicators mentoring program that you've already mentioned.
Yes, the Defence was a participant, a Defence team was a participant in that.
You've referred to your new access program. You've already mentioned that in passing at least. Early intervention, that's available at the moment to Defence employees but not ADF members, you note, at 206.
So the program that program has finished. It was one of those showcase ones where, you know, there's some now products on our website for in parts of the jurisdiction who might want to use that idea as one of their controls, for instance, can take that up.
Thank you. I just want to go back to the reports of notifiable incidents over the period covered by the table at the top of page 11, I think it is. That's calendar years 2015 to 2021. So back on page 11 of your statement. The final column of that table over on the extreme right-hand side is serious sexual assaults, whether there are serious sexual assaults that are notified as notifiable incidents. And essentially, this is making it clear that Defence didn't notify any serious sexual assaults to Comcare in any of those calendar years, 2015 through 2021. Is that right?
Correct.
Has Comcare looked into the accuracy of that state of affairs, whether in fact there were no serious sexual assaults, or do you have any hypothesis as to why none would have been reported?
The work of our new psychosocial inspectorate we'll be looking at data from those organisations, trying to get in, you know, into the organisation, and there will be an opportunity for us to compare why.
Okay. You don't have any current hypothesis?
That team is just in a pilot phase at the moment, so.
Right. Commissioners, I'll leave it there. I've gone over time, but I don't know whether I've left you any time at all, but perhaps if you take a little bit of time to ask the questions you need to ask, and we'll adjust the timetable accordingly.
Thank you, Mr. Gray. Commissioner Bell.
Thank you. I do have some questions. Thank you, Ms. Weston. Can I just ask, you did indicate, I think, that in addition to the notifiable incidents, there are other ways in which Comcare is informed about potential issues, and that I think you talked about complaints and media reports, etc. Is that correct?
So we call them WHS concerns. So they could come from a variety of ways. They could be someone telling us that something's happened. It could be a complaint. It could be media. It could be other intelligence that we get from somewhere else. So it's another set of pathways for us to check that the PCBU is undertaking that, you know, analysing the hazards, risks, controls, and talking to the people and checking. So the framework they should be in relation to psychosocial hazards.
So do you quantify those WHS concerns, or is it just more qualitative in terms of?
So they feed into the database that we have and the risk model for each part of our jurisdiction.
And so can I ask you then, in terms of the WHS concerns around suicidal ideation, suicide attempts, in relation to Defence and ADF, has that been a significant WHS concern under that heading, as opposed to the notifications that you've received from Defence?
we still don't have the visibility that I'd like to see, although we have had, one of those concerns leading to significant inspection activity by us.
Okay, thank you. The next question, you said during part of your evidence that there is a procedure to follow in the event that there is a fatality or a significant incident of self-harm, and it lists various things for your inspectors to consider. I'm not going to ask you to be able to list all those things that it asks for, but I'm assuming that part of what they're looking for is to determine or come to an opinion about whether or not the event arises out of the work of the business or undertaking. Is that part of it?
That's part of it, yes.
So in the event that there is a suicide death of someone in the ADF, and your inspectors are following that procedure, can I just ask in kind of broad terms, how would they be making that assessment about whether it's arising out of the work of the business or undertaking? And I'm particularly interested to know how broadly they might make their inquiries, beyond leadership to, for example, ADF members.
So an inspector needs to form a belief about whether there's something that's happened or not, and they will look at the information, and they can go broad. And if we're in a serious investigation phase, there may be experts that we use as well.
So when you say that, okay, it's probably difficult to go beyond that. Thank you. My next question relates to the challenge of latent effects. I think people are familiar with the concept of exposure to asbestos, risk of mesothelioma many, many years down the track. Of course, we also have the potential risk of exposure to an event or a particular trauma, and impact, not necessarily immediately, but with some lag time, potentially many years. In all of the work that is currently being undertaken in relation to psychosocial risk, psychological injury, is that issue of the lag being considered?
I just have in my mind that there was some mention around that in... Can I take that back and answer that for you after having a look at the Boland response and what's happening with Safe Work Australia?
Okay, that would be very helpful. Thank you. My next question is just in relation to the role of Comcare. We've been advised that, and there was questions in relation to the evaluation of the Defence Mental Health and Wellbeing Strategy, and we've been advised that DVA also has a mental health and wellbeing strategy, and that following the recommendation in the Productivity Commission report to have a single strategy, work will be undertaken to develop a joined up strategy to be published after the expiration of the current ones, which is I think 2023. I'm just wondering whether Comcare has been involved at all in any discussions around the development of that joint mental health and wellbeing strategy between Defence and DVA.
I'll take that on notice for you. It is interesting though, because that fits into that space where I think that those international standards might fit in, and the code of practice for managing psychological matters in the workplace. And while it's early stages for our psychosocial inspectorate, it might be valuable for them to be working closely with those two groups.
Mm. And my final question is just in relation to the comments that were made, the data that was presented about an observed increase in calls to open arms following the release of the Brereton report, and you indicated you weren't aware whether a number of calls to open arms had continued. My question is, has Comcare taken any steps in terms of monitoring the potential impact of that?
So, yeah, I think the statement, the veterans element of the Workplace Health and Safety Act doesn't extend into that post-work situation, which has been a bit of an issue there. I'm just trying to remember your question, Commissioner.
I'm just essentially wondering whether, in terms of looking at psychological injuries post-Brereton,
Yes.
whether Comcare has taken any particular measures to continue to look at that or monitor that.
Certainly the establishment of that inspectorate is aimed at making sure we get some visibility of the issues of psychological injury. And, but, you know, I will check to confirm about the follow-up of the Brereton report.
Thank you very much.
Thank you, Commissioner.
Can you pick me up? Good, thanks. Thank you, Ms Weston, and thank you for your evidence. I only wanted to explore one issue with you. It related to the question that speculated whether the differences between the AIHW figures and the Comcare figures might have been based on the conclusion that Comcare decided that some of the deaths were not work-related. Is there a significant financial consequence to the deceased person's estate, depending on that conclusion?
Not that I'm aware of. Comcare doesn't provide compensation or the scheme is not about, it's a safety systems regulator.
So there wouldn't be a financial incentive in an estate to challenge that conclusion?
I have not been made aware of that.
Thank you.
Thank you, and thank you again, Ms Weston. I have one very brief point, and I don't know whether we need to bring this up or not. It's question 30, which was on page 53 of your statement. You were asked at the end if you formed any other opinions that you consider to be relevant to the Royal Commission's terms of reference. And the issue you raised at point 223 is one of concern, and it's really about data management or data keeping, if you like. You've mentioned that Safe Work Australia compiles the work-related traumatic injury fatalities data, but they do exclude, I'll summarise, they exclude death by suicide with an explanatory note stating it is difficult to assess the extent of the connection between work and a decision to take one's own life. And I just wondered, that is something, as you're already aware, I'm sure, and if you've been following the Commission's hearings, it is something that's come up again and again. The accurate data, which can then hopefully help everyone manage the problem. Where do you see that going? What's the solution to this? I mean, you've made a sort of recommendation there, if I can use that term. Where do we go from here?
So the information that's available misses a critical chunk. There will be some instances of self-harm where there is a work-related element, but there's other related elements, as you know, and it's not about. It's just to try and make sure that there is some visibility of that part that's happening. And I know it will be hard. This will be a hard job, and so we'll be looking beyond the workplace for something that might happen after. But nonetheless, I think that it's worth trying to see if we can get that information and make it available for people who are looking at this important issue.
It's certainly an issue, as I'm sure you appreciate. Perhaps it's something that we can discuss with your office as well at some stage about seeking your views as to the solution. It is a very real problem. If people don't know the accurate statistics, they don't know the magnitude of the problem, and without, as we've said before, if they don't delve into individual cases to try and assess what caused it, then we're never going to get anywhere. And clearly at the moment they're not doing that. They're not even delving into individual cases. So, but thank you for your evidence today, Ms Weston.
Thank you, Commissioners.
Mr Fordham, is there anything you wish to raise?
No, thank you.
Mr Craig, if you're still with us, are there any questions you wish to raise?
Thank you, Mr Chair.
Might I just ask a clarifying question arising out of Commissioner Douglas's question?
Sure.
Thank you, Commissioners. You were asked, Ms Weston, about the question of the disparity between the AHW figures and the Comcare figures for reports of notifiable incidents, and it was suggested that Comcare had decided that some of the deaths were not work-related, or that was the suggestion that the writer
It's one of
that
the
report was.
possibilities, yes.
Is it actually a question of Comcare deciding that the deaths are not work-related, or is it a matter for the PCBU to make that assessment on its own, or is it a mixture of the two? Are there some cases in which the PCBU makes that assessment on its own and some cases in which Comcare makes the decision?
No, the primary duty lies with the PCBU. Sometimes, though, when it's come to an inspector, more information becomes available that allows the inspector to form a different view. I wouldn't expect there to be a significant number of those, but that is available to our inspectors, based on the information they have.
And those figures on numbers of notifiable incidents reported to Comcare in each calendar year, are they reports that flow only from the judgments of the PCBUs about whether the relevant incidents fall within the scope of the obligation to notify, or are they
They would be net.
net?
Yeah.
So some of them might involve inspector input as to whether the matter
That's
should
right.
have been identified.
That's right. That's right. That is an
Thank
option.
you. Thank you very much. No further questions.
Thank you. If there's nothing arising, is the witness to be excused from her notice to appear?
Yes.
Okay. Thank you, Mr Craig, and thank you, Ms Weston, for your appearance today, and you're excused from the notice to appear. Thank you. We'll adjourn for a very brief period. We're running way behind.
All rise. The Royal Commission will now adjourn until 12:20. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Thank you, Mr. Connor.
Commissioners, will now hear from Mr David Morton, Captain Glenn Kerr, who is Provost Marshal of the Australian Defence Force, and Brigadier Amon Lenihan. You'll hear from these witnesses about the so-called defence registers. Commissioners, just before we commence on defence registers, may I just say, put this in context a little bit. One notices when one looks at paragraph A of the terms of reference, that's one of the 10 paragraphs of the terms of reference. It identifies or requires a commission to inquire into systemic and common themes amongst two groups of people. And one of the groups of people referred to is those defence members and veterans who have, and these are the words, other lived experience of suicide behaviour or risk factors, including attempted or contemplated suicide, feelings of suicide, or poor mental health outcomes. The Royal Commission has been and will continue to examine the experiences of these members and veterans who have had this lived experience in all of the hearing blocks. Another group of people referred to in paragraph A are those who have tragically died by suicide. And this, of course, will have affected many, many people and have changed the lives of those people. Another group, of course, and we've heard something about this, is the families of current members and former members. In this panel, Commissioners, will be focusing upon the registers that Defence is maintaining concerning deaths by suicide. In speaking of deaths by suicide, we don't wish in any way to diminish the suffering of serving members and former serving members who've experienced the feelings that have taken them to points where they've attempted or contemplated suicide, or have feelings of suicide, or have experienced difficulties with their sense of well-being. If hearing about defence suicide registers is at all troubling to any members of the public, you may not wish to listen to this session. If you're having any difficulties, please seek help. The Commission has a team of counsellors who can assist and guide you. And shortly, Mr Morton will speak on this same matter. Commissioners, or operator, might you display the Defence Register panel tender list? Commissioners, you'll see 15 items on this list. Some of the items have already been tendered in evidence. And that's marked in the third column where there's exhibit numbers. What one sees in this list, items 2 and 3 concern the notice to give to Defence .001. Commissioners, I tender items numbered 2, 3, 4, 5, 6. My apologies, Commissioners, withdraw that. I tender items 2, 3, 7, 8, 9, 10, 11, 12, 13, 14 and 15. Now, some of those items are subject to confidentiality, and I'll list those items. They are item 1, item 6, item 7, item 8, items 11 and 12. Commissioners, I call Mr Morton.
Just before you do, obviously, say that they'll be accepted and allocated the next consecutive numbers, subject to the restraints that you've mentioned. So.
Thank you, Commissioner. I call Mr David Morton, Captain Glenn Kerr and Brigadier Amon Lanahan.
David Morton, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Captain Kerr, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Brigadier Lanigan, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr Morton, I invite you to say something concerning the context of this particular panel.
Thank you very much, Mr Connor. As you've said, the title of this panel is titled Defence Registers, and we expect we'll be asked to discuss and describe data relating to recording the deaths by suicide of serving and ex-serving ADF members. As such, listeners and observers will hear us talk about the numbers and rates of death by suicide, comparisons between groups, populations and circumstances, and assessments of the relevance of various risk and protective factors. We recognise that there are people behind each and every number. Each suicide is a tragic loss. It represents loss for the person, their life and career opportunity, loss for their family and loved ones, mates, work colleagues, and for us as a whole community. The effects of suicidal behaviour and suicide attempts can also have impact on those individuals and their loved ones. In many of these circumstances, the loss of hope and sense of despair experienced by individuals can be seen through their actions. For this reason, while a discussion around data is very important, we would like to recognise that this in no way diminishes our awareness of the very human and far-reaching impact of every single death by suicide and every case of suicidality. We recognise that data is only one source of information that can improve suicide prevention. The most important source is people themselves, their families, mates, supervisors and commanders, chaplains and health professionals. While discussion about numbers of deaths is required and will help us in the long run, it's the people who are important, and even one person willing to have a conversation can make a difference. For those listening, watching or reading the discussion of this panel who may be experiencing suicidal distress or are concerned for someone else who is experiencing such distress, please don't allow the numbers to stop or delay you from reaching out and seeking help or support, no matter what the cause. It's never too late. There are many avenues in defence and outside of defence for you to reach out to someone, a family member, a mate, a supervisor, a work colleague, chaplain, health professional, garrison health centres, open arms. A simple, caring conversation can make the difference and help someone move from despair to hope and survival. Thank you.
Mr Morton, you joined the Australian Department of Defence in 2010.
That's correct.
And you're appointed to the newly created position of Director General, Mental Health, Psychology and Rehabilitation within Joint Health Command.
Yes.
You'd previously worked with the Department of Defence for the Department of Veterans Affairs for nearly 20 years.
Yes.
And you'd spent 1 or 2 years prior to that with Defence.
Yes.
Now, you were responsible for formulating the 2011 ADF Health and Wellbeing Strategy,
Yes.
and you're responsible for formulating the ADF Alcohol Management Strategy and Plan,
Yes.
and you were responsible for formulating the Defence Mental Health and Wellbeing Strategy 2018 to 2023.
Yes.
Captain Kerr, you joined the Royal Australian Navy in September 1984,
Yes.
and you've spent a period of time with the Inspector General of the Australian Defence Forces Office.
That's correct. 6.5 years consolidated.
And in what years were they?
2009 to 2013, and then 2017, 2018.
And you were involved there principally in the area of military justice.
Correct.
Now, from January 2020 to January 21, you were posted to the position of Deputy Provost of the Australian Defence Force.
Deputy Provost Marshal ADF, that's correct.
And that's concerned with military justice principally.
That is correct.
And on the 18th of January of 2021, you assumed your current position as Provost Marshal of the Australian Defence Force and Commander of Joint Military Police.
That's correct.
Brigadier Lenihan, you joined the Australian Army in 1991. You were commissioned into the Royal Australian Infantry from Duntroon in 1994.
Yes, that's correct.
And you're presently the Deputy Head of Defence Force supporting the Royal Commission into Defence and Veteran Suicide.
That's correct.
And how long have you been in that position?
Since May 2021.
Thank you. Operator, might you display NTG Def 021? Now, you each are familiar with this response by Defence.
Yes.
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 And who was involved in the, were each of you involved in the preparation of this document?
Yes.
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 And you are satisfied with the responses in this document?
Yes.
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 Operator, might you go to the next page and display paragraph number 1, please? Commissioners, paragraph number 1 displays 3 registers that Defence maintains concerning suspected and confirmed suicides. And the witnesses will be giving evidence about each of these registers. Now, Operator, might you display on page 14, paragraphs 36 through to 40. Commissioners, the notice tells us that that Defence has maintained a Defence suicide register, which is item 3 in that list, and also maintained a Joint Military Police Unit suicide register. The Defence suicide register, which was commenced under preparation, I think, in 2014. Is that correct, Mr. Morton?
Yes.
And that covers or includes deaths by suicide since 1 January 2000.
Yes.
And it includes, it's principally permanent members. Is that correct?
It's members who at the time of their death were serving full-time.
Thank you. One then sees as item 4 the Joint Military Police Unit Suicide Register, and we'll come in further detail to that. And that was commenced under preparation, I think, Captain, in July 2019,
That's correct.
and it took about 18 months to compile.
That is correct.
And it was compiled from, amongst other things, paper records going back to 1970
That's correct.
and perhaps before 1970.
We examined the records back to 1965, but 1970 was the first actual record of a suicide.
Now, commissioners, you commissioners are well familiar with the Australian Institute of Health and Welfare list, and this is the list of, I think, 211 deaths by suicide amongst permanent and reserve members up in the period from 1 January 2000 to 31 December 2019. There's a fourth item there, which is the Interim Commission, National Commission for Defence and Veteran Suicide Prevention list. This is Dr. Boss's list. And will come, and what has been created is a consolidated register of suspected and confirmed suicides, consolidated from those four items. Now, operator, might you display question, sorry, Commissioners will commence with the Defence Suicide Register and then move to the Joint Military Police Unit Suicide Register and then move to the Consolidated Register. Commissioners, you'll see at pages 7 through to 12 of the document, reference to responses to questions concerning the Defence Suicide Register. Now, might we come, operator, to page 8 and the response to question 2E. At the foot of the page, please, operator. Commissioner 1 sees here fields or items of information within the Defence Suicide Database. This is the Defence Suicide Database is a matter that you can principally speak to. Is that the case, Mr. Morton?
Yes, it is.
Now, you were involved in directing its preparation?
Yes.
Now, and you're involved in identifying the relevant fields to create, were you?
I certainly was involved in terms of agreeing that the fields would be finalised. In the identification of the fields, there was a series of people who were tasked to go forward and identify the fields.
Now, Commissioners, you'll see on the next page, page 9, if you might display page 9, one sees another list of fields, and then again on page 10, and that's a total of, I think, 61 fields. We'll come back to those fields. Now, what was the purpose of establishing the Defence Suicide Register, and what caused it to be created?
So its purpose was to establish essentially a surveillance document that would allow us to have a more accurate understanding of the numbers of ADF members who died by suicide while serving full-time in the ADF. Principally, it was to try to enable us to have a more accurate understanding of the numbers of those deaths.
When we looked at those fields, are they the only fields that are in the Defence Suicide Register?
I believe so. They're the fields that we've provided you the latest record of the fields.
Now, what event caused you to think about creating the Defence Suicide Register?
There wasn't necessarily one event. What had been occurring for a period of time prior to 2014 was various attempts to pull information together in order to establish the number of deaths that had occurred by suicide. In 2012, we commissioned the Australian Institute of Suicide Research and Prevention to undertake a review of our suicide prevention program, and that included some further advice about surveillance. We also, at the time, Joint Health Command was moving towards and had adopted and was going through the process of implementing a new e-health record system. So that provided opportunities to be able to start to look at collecting data. And there were a number of situations where we were being requested and asked to provide information about the numbers of deaths. So there was those situations and opportunities were leading us to look at ways in which we could improve the accuracy of our understanding of the numbers of deaths by suicide.
It's not simply numbers though, Mr. Morton, it's beyond numbers, isn't it?
It's beyond numbers. So we looked at what is the information expressed through the data fields, which have progressively been added to since 2014. But we initially started by having a look at what could be provided to us through the psychology records, the health records, and from the PM Keys personal management system in terms of looking at information from those sources initially, and then it grew from there.
Now, you're saying in this response that you responded to recommendation 9 of the 2012 AZAP review. That's correct, isn't it?
I'm saying that was part of what was occurring at the time as we were looking at ways of achieving a better understanding of what we could understand of suicide deaths that were occurring.
You have said, though, in your response that it's been completely implemented.
Yes.
Implemented in full. Is that the position?
You might want to take me to the response, but my understanding is that we've said it's been fully implemented. So yes, it has been implemented.
Fully implemented?
I think fully implemented to the extent that it can be implemented, given that we have continued to look at ways in which we can add data fields that become more relevant or we understand to be pertinent as we've progressed. But it's been fully implemented.
In its terms?
Can you explain to me what you mean by in its terms?
Operator, might you display page 19 of the response to the notice to give? At the top of the page, one sees a recommendation 9 of the, and I'll give you an opportunity to read that.
So forgive me, I thought you were talking about just the implementation of the Defence Suicide Database itself. What I understand you now meaning is the implementation of recommendation 9.
Yes, now the implementation of recommendation 9, is that what else apart from the Defence Suicide Database did Defence do following this recommendation?
So following the recommendation, we also progressed to look at areas of information and data that we could better understand and collate that would go to looking at suicidal behaviour.
And is this in the Defence Suicide Register?
There is additional work to the Defence Suicide Register that looks at suicidal behaviour such as ideation and planning and attempts. But it's also, if I may explain, it's also fair to say that a number of the data variables within the Defence Suicide Database contain information about those sorts of behaviours or those sorts of instances amongst those who've died by suicide.
Now, are you saying that there's some other database or some other body of material apart from the Defence Suicide Database that constitutes the implementation of ASAC Recommendation 9?
I'm saying that Defence progressed from receiving their ASREP report to look at doing further work around suicidal ideation behaviours and understanding of that goes beyond Recommendation 9.
But Recommendation 9 concerns Defence improving the surveillance system to track suicides.
It does, and in actual fact, we did that through the Defence Suicide Database to track suicides.
Now, you referred to attempted suicides there.
I referred to suicidal behaviour, which is additional work that has been undertaken progressively from the same period where we have tried to get an understanding of suicidal behaviour.
Is there another database that's connected with Defence tracking suicidal behaviour?
There's not specifically a database as yet. We've been looking to develop a defence monitoring system, which is what we refer to in evidence that we've provided to the Commission already. And that's a body of work that's occurred, but there is no specific database.
When do you say you commenced that work on the suicidal behaviour work?
Yep.
When?
When did it occur? Yep. We started looking at that work from the time of approximately 2016, where we started to, we formulated some work to undertake some audits and understandings of suicidal behaviour instances that had occurred with ADF members using the Defence eHealth system.
Have you provided that body of material to the Commission, to your knowledge?
I'm unsure whether that material has been provided under the areas that you've requested information about at this stage, but it remains available.
And what would you ask for? What would you ask for? What would the Commission ask for?
We have referred in documentation that we've provided and background information to the Commission. We've referred to work that's being undertaken to try and formulate and develop a Defence suicide monitoring system. And we've referred to that in written documentation we've provided to the Commission as background information. And so we would happy to talk about that, but also we would be able to provide the information about the work that we have undertaken.
Now, operator, might you display DEF.1000.8002.9688 and come to page 93. This is, of course, the 2012 ASRAP report, and it's recommendation number 9 that recommended that Defence improve the surveillance system to track suicide data collection should be systematic and well coordinated. Yep. Now, do you say that it's been systematic and well coordinated since that point in time, do you?
I certainly say that it has been as systematic and as well coordinated as we have been able to achieve within Defence, given the need for and the understanding of the emerging knowledge and understanding that has occurred around these sorts of activities in the broader community, including defence.
You'll see in sentence number 2, as highlighted by Dr. Zamorsky, rich data on the total set of circumstances surrounding the suicide are required.
Yes.
For this, a systematic approach to suicide investigation is needed.
Yes.
This should include interviewing the family of the deceased. Did this occur?
That action doesn't occur by Joint Health Command or as part of the Defence Suicide Database. My recollection of the report is that that there were a number of activities that were being identified internationally that went to different ways in which information was collected. And I note the use of the term there, investigation. The purpose of the Defence Suicide Database was not to achieve an investigation, it was to in fact provide an understanding of the factors that would be relevant in relation to surveillance.
So did Defence pay proper attention to the first paragraph under recommendation 9?
I believe we paid attention to recommendation 9 in being able to have a look at what was available to inform the information that we needed around defence suicide deaths. I recognise that the issue of speaking with families is an activity that has occurred over in Canada, which is what was being talked about there. And I would recognise there are other areas of defence outside of Joint Health Command that do have conversations with families.
But you were told this in 2012.
Yes.
When were you acting in 2014 to interview families?
No, I can say that we didn't act in 2014 to interview families.
When do you think Defence started to speak to families? That's Defence itself and not some other organisation.
Defence has been speaking with families in many different ways for a long period of time. Are you referring here?
I'm sorry.
Yes.
I'm asking a question about a death by suicide.
Right.
That's the very context.
Yep.
And the witness is entitled to clarify the question if he's to answer it.
I'm speaking here about deaths by suicide and the first paragraph.
Yep.
And families in that context. So could you restrict your answer to families of persons dying by suicide?
We have not, in order to fulfil the Defence Suicide Database, instituted a means by which we would interview families for the purpose of getting information that would be in relation to the Defence Suicide Database.
Or in any aspect apart from the Defence Suicide Database? You haven't done it.
No, I cannot point you to a systemic way in which that's done by Defence, but in saying that, I do know that Defence do have a number of ways in which other areas of the Department, apart from Joint Health Command, do engage with families and do talk with families when there has been a suicide.
Now, you'll see the second paragraph under the recommendation 9, data collected should include the following variables.
Yes.
Now, factors relating to potential triggers. Is that covered in the Defence Suicide Database? And if so, in what field?
If you're looking at specific potential triggers, they may be many and varied, and they may be hidden across a number of factors. They could go to triggers that relate to the indication that somebody might be single rather than married, for instance.
To get to the nub of it, did you have close regard to this paragraph in formulating the Defence Suicide Register?
Yes, we have had regard in order to look at the range of data variables that we chose to put in the Defence Suicide Database. that helped us understand some of the range of factors that could well be triggers.
Now, are you satisfied that the Defence Suicide Register database has all the relevant fields covered?
I'm satisfied. I'm satisfied that we have a number of the fields covered in it, but as I've stated in the evidence that we've presented in the notice to give, we've indicated that this continues to be an emerging area that benefits from being able to look at the different sorts of data data and factors that come from the field of suicide prevention that indicate they can be informative, but is also affected by the identifying and locating data across complicated systems to bring them together to help understand those factors as they relate to an individual suicide. So it's not complete in the sense that I would be able to say to you, we have got all possible factors and all possible potential triggers.
Operator, might you display in the same document page 54, which is .9747, and might you display the final paragraph on that page? Now, this states international experts identified various possible risk factors for military members, and there are 14 matters listed.
Yep.
Did you pay attention to all of these in constructing the Defence Suicide Database?
We paid attention to in my looking at them, I'd say we've paid attention to all of those and more factors that have become apparent as we have progressed since 2012.
Have you covered, for example, item number 2, large amount of training? Is that covered somewhere?
Within the database, what's covered is the length of time that somebody has been in service prior to that.
But that's, with respect, not an answer to my question. It's about training periods.
It is about training periods, but what I would suggest to you is that information and data such as length of time that somebody has been in the Defence Force goes to being able to go forward and then seek further information about the individual circumstances and the sort of training they've undertaken, because it's indicative of the sorts of period of time they've been in the Defence, whether they've gone through recruit training and other elements of training. So does the database itself hold information about large amounts of training? The database itself does not, but the information in the database enables one to be able to go forward, particularly knowing the information about identifying the individual, to go further to find that information if that was necessary. Not necessarily in the database, but in the other areas of the department that would hold information about the service of an individual.
Now, of course, or not necessarily of course, but physical training and injury can be connected with a sense of a lack of mental well-being. Is that being mapped somewhere?
It's not being mapped in the Defence Suicide Database, but it in fact would be information that would be held within the individual's e-health record in terms of... Sorry? Sorry, I thought you were... it would be information that would be held in the individual's record in terms of injuries and illness that's occurred and the treatment and rehabilitation that would have been provided. There would also be other sources such as, which I'm not an expert in, but things like the Work Health Safety Sentinel system. There would be information about injury and injuries that may have occurred through training and other circumstances.
Now, to take item 4, an exposure to trauma, is that covered directly in the Defence Suicide Database?
We certainly identify whether there has been deployment, and we also identify information or what I might say is the results of screening that's occurred for those individuals with regard to things like the return to Australia screen, this post-operational psychological screen, which includes measures that go to psychological alcohol use as well as trauma exposure.
What about item 6, exclusion from group, particularly due to disciplinary action?
The database would identify where we've been able to identify it, whether there has been administrative action that has occurred. But again, it wouldn't hold the information about what that would be. It would then enable that information to be sought or identified in other areas of the department.
Now, risk of contagion among younger members. Not really covered, is it, in the Defence Suicide Database?
It's unclear as I look at this now about a specific data field that would be identifying possible risk factors. However, when I look at issues to do with the fact that we identify gender, we identify other demographic information of age, and that we know that a higher proportion of our the deaths that we have recorded on the database are younger ADF members, I would say to you, I think we have information in there around an indication of the age groups and therefore the numbers of younger members who are recorded to have died by suicide.
Now, some material is in the Defence Suicide Database.
Yes.
What analysis, if that's the expression, or assessment of an individual death by suicide is carried out by the Defence Force itself?
So the analysis that we certainly use in relation to the Defence Suicide Database is information that would come from the person's e-health record, from their PM keys, personal management system information. Sorry?
But just standing aside from the Defence Suicide Database itself, your evidence, I think, is that it leads one to other material in various sources.
Yep.
Now, is Defence itself conducting an analysis of the individual death by suicide?
So Defence has a number of mechanisms that go beyond Joint Health Command that looks at achieving an understanding of the circumstances of somebody's death and death by suicide. If that's what you're referring to about the information that is brought together in order to better understand those circumstances, that occurs in a number of different areas in different parts of the Department of Defence.
Is there anyone it's their role to examine in a consolidated way the person's death within Defence?
Well, yes, there is, and I think the best way that I can assist you with that answer is to indicate that every death within Defence will be the subject of an investigation. There'll be, and certainly deaths by suicide, go to be an investigation or a determination or an assessment through referral to the Inspector General of the ADF by Defence. But that's an area beyond the area of looking purely at data in relation to Defence suicides.
Now, I asked you to speak directly about Defence,
Yes.
and not IGADF, is implicit in my question. Now, does Defence itself do an analysis of why someone may have died by suicide?
So certainly I think there are, I can speak for a number of parts of Defence where we gather information when a person has died by suicide. So that would include a process by which on receiving a FATICAS notice that has been generated, if the Surgeon General will request information that goes to gathering the health-related information of a person who has died by suicide. And we would then also seek information from JMPU to confirm whether it is a suspected suicide at that stage, in order to be able to look at initiating and starting to keep some record of that information. There are also processes within the each of the services where they would gather information around the death. I think part of your question is anybody pulling all of that information together? What I would say to you is that I don't believe that there is a location that's pulling all of that information together, but much of the information that we collate from their access to healthcare, from looking at the other aspects around their behaviour, is something that we've progressively been trying to develop and progress the Defence Suicide Database, which is one of the reasons why we've progressively added to those variables. We are in the process at the moment of trying to progress that further by looking at how we can best look at ways in which we can connect data that we have collected from the Defence Suicide Database to other areas of the department that would include things like complaints handling, other areas of the department. That work is currently underway.
Am I correct in saying that Defence does not have a consolidated review of a death by suicide?
I don't think I'm able to answer the question for you, to be honest, Mr. Connor. The only observation I can offer you is that I'm unclear about what you're meaning by consolidated review, because there are a number of reviews. There are reviews that would occur into a death. If those and I acknowledge, with respect, I acknowledge that you're not wanting for me to identify the fact that it's referred to IGADF, but in actual fact, those referrals to IGADF provide the opportunity for them to collate information from Defence and from a whole range of other stakeholders that enables a better understanding of the circumstances of someone's death to be assessed and for determinations to be made. There are circumstances that have occurred where information that has occurred as a result of that also then comes through that process back to relevant areas to look at suggested changes or opportunities to look at changes or requirements that may need to be addressed as a result of those findings. So it's the best I can offer you in terms of a consolidated approach to the range of information that is likely to be available around suicide deaths and suicide factors.
What investigation or analysis is carried out by Defence of incidents of risk factors in each case of death by suicide?
So I think the analysis would be, as I've described, from the situation of looking at the personnel's use of healthcare, from looking at their presentation to healthcare, if that has occurred, and in some circumstances they will not have presented to healthcare at the time of their death. But there would be other information that would flow from the other means that I've described to you that would come together in terms of recommendations that would then be part of recommendations oversighted by bodies such as Office of CDF to ensure that certain issues are followed up or there is action that's been taken. If something has been identified as being of a significant issue in relation to the circumstances of a death, they would include suicide factors. Can I give you an example of one maybe? Would that assist?
we've got only a short time.
Sure.
But if,
So an example of one would be from a death that's occurred a number of years ago, where the out of the investigation of the death, it was identified that the individual had made a statement to a number of people that had been perceived as a joke. Action had not been taken in the way that it should have been taken as a result of that. One of the follow-ups from that was, in actual fact, to have a look at what guidance and education we can provide around the issues of how people can make light of their despair and loss of hope at times, and that being a suicidal factor. That then progressed to being part of how we went about injecting that into suicidal behaviour education training, but also into policy and into information for commanders and for our health providers. It's only one example, but it's something that does not necessarily show up in a database, but in fact does show up from the overall review of circumstances and goes to then the actions that can be taken from that.
now, I'm just trying to identify that review of circumstances of that particular death. Who undertook that? Wasn't someone in defence, was it?
We're going back a number of years, and I think to be accurate in an answer for you, I would say to you, I don't have the specific information of who at the moment. I have no doubt that we would be able to make that information available to you.
Is the broad position that you substantially rely, that is defence substantially relies on the IGADF to carry out a role in investigation of deaths by suicide?
No, I think the broad position I feel like I'm explaining or trying to explain is that that's one of the avenues from which information is drawn and is provided to, but there are others that I've mentioned, which is to be able to look at the review of their clinical care, the review of healthcare that's provided, information that may come from other circumstances. I'm indicating that there may well be a collation of all of that where there has been an investigation or a review of the suicide in that sense. But there are a number of levels of review, from clinical review and what that means for the individual and what it means for ongoing changes to policy or programs or education. I'm suggesting to you there are a number of ways in which information can be sought and found and discovered.
I'd like to distinguish between the information that's in systems on the one hand,
Sure,
versus analysis on the other of those bodies of information. What were you last talking about? Both matters?
I believe I was talking about both matters because I see that in actual fact they're highly related.
Interconnected, can I put it to you that way?
I don't know that I object to the word interconnected. They're very much related.
Now, you say the Royal Commission could obtain from Defence documents constituting an analysis of a death by suicide for each of these cases of deaths by suicide.
No, I'm not saying that. I'm saying that in actual fact there is information that the department would be able to have around the situations where it has conducted reviews, clinical reviews, other reviews, investigations that have progressed to investigations. That information is something that the Royal Commission could request and be available. What I'm suggesting to you, and I'm sorry if I haven't been able to explain this clearly, is that I thought your point was going to, so is this all collated in one place? My suggestion to you is my observation is it's not collated in one place.
Sorry on this point. Not collating the information in one place,
Sure.
Having a document that constitutes an analysis by someone of the entire set of circumstances of a particular death by suicide. Is there such a document within Defence?
I don't believe that there is such a document that would pull all of that information together, but I do believe that there could well be documents that in actual fact pull and refer to aspects of information that are in other reviews. But I'm unclear as to whether I don't believe I can say to you there is one document that necessarily pulls together all of that information in one place.
Now, you've heard that the Department of Veterans Affairs has conducted a pilot project in July 2019 for an adverse events analysis concerning deaths of veterans. And you've read of the evidence that they gave about that process. Has Defence considered such a process?
I think Defence, so has Defence considered the process that DVA is putting in? I don't believe we've necessarily considered the process that they're describing it because it's still being evolved and determined. But Defence does already have mechanisms in place that look to the questions of how to look at adverse events in health systems. And I note that you'll be talking to us on the healthcare panel around and have the opportunity for us to talk about those matters in more detail if you want us to.
But of course, a death by suicide is the ultimate adverse event, isn't it?
I wouldn't say, I would say yes, yes.
And Defence hasn't yet given consideration to analysing these deaths by suicide by a process, an adverse events exploration process?
Mr. Connor, I don't know whether I'm agreeing with Defence has not looked at whether it would apply an adverse events process as described by DVA into looking at deaths by suicide. But Defence does have systems in place that will examine adverse events as they may well occur and in the circumstances in which they occur, both within the health system within Defence and delivery of healthcare within Defence. Whilst I would say that every suicide that occurs can very much be interpreted as an adverse event, it really goes to whether you are, how you're defining adverse events in relations to a system, which is very often the way that adverse events in relation to systems are considered. And so I think it goes to what you're meaning by adverse events investigations.
The evidence from the DVA was an analysis of an individual case. It's perhaps an unfortunate label for it, but it's an investigation and an assessment of an individual case in a coordinated fashion.
And at the moment, just on those words, I would say that Defence has a number of ways in which it currently collects and reviews information about the circumstances of an individual case that go to a range of areas such as whether that person, when that event has occurred, their engagement with the healthcare system, how they would have engaged with a command would occur through the single services. So I'm not meaning, and I hope you're not interpreting my response to the DVA one, to imply a tool that Defence does not look at adverse events. We certainly do. And I've explained in previous evidence and now that there are a number of ways in which we do it. And they go to clinical reviews that would occur. They would go to reviews that would then deliver us information about learnings that would occur around the system, learnings that would occur in relation to making sure that information is available for members, information available to command. It would also encompasses the more formal investigations that would occur in those circumstances where Defence has referred to IGADF. So I'm not implying at all that Defence does not undertake any review of adverse events. But what I would also say is that we are confining ourselves here, I trust, just to the question of suicide deaths when we're talking about an adverse event.
Yes.
Right.
Now, there's 183 names in the Defence Suicide Database at present?
Yes.
How many deaths by suicide have you had amongst permanent members this year?
This year, 1.
And last year?
10.
And in 2020?
9.
Now, might we turn to the Military Police Suicide Register? Thank you, Captain. Might you just shortly describe for the commissioners how this was created?
So the Joint Military Police Unit Suicide Register was not created due to any particular direction or any particular event. It was I suppose, the culmination of a number of historical processes, starting in 2013 with our Project Millennium, where we began to try and pull together and consolidate military police records, which to that point had been distributed across the country under a number of different authorities. That then led into 2014, where we were assisting the Joint Health Command, providing information as they were developing the Defence Suicide Database. At which side we realised that we had records that went back beyond the 1st of January 2000. And based on our previous experience of the Defence Abuse Response Task Force and the Royal Commission into the institutional response to child sex abuse, we realised that if there were going to be future examination of defence suicides, that we would be required to provide information to any such oversight body or research body, usually at very short notice. And so the idea was to create a consolidated list of all suicides that we had on record, so that we would then be able to data mine that and respond as quickly as possible.
And you found on that register, I think there's 328 confirmed or suspected deaths by suicide.
That's correct.
And now they are mostly of permanent members of the Defence Force.
So they are primarily permanent members, but the database, the register does also include reserve personnel, ex-serving members, foreign personnel and civilians.
How many of each of those?
I can't say off the top of my head.
It's not provided in the information here. It's spoken very generally in response to paragraph 8. Is there some reason for that?
Because I was not asked specifically for numbers. They certainly can be provided.
Can be provided. Thank you. Now, then there's a consolidated register. And Brigadier, I understand that you're involved in the development of the consolidated register.
Yes, that's correct, Mr. Connor.
And Operator, might you display paragraph 36 again, that page? My apologies. Page 14 of the response NTG Def 21. Thank you, Operator. Defence Suicide Database has 182 people listed, 183 people listed. The Joint Military Police Unit Register has 328, I think, listed. Might I just turn to paragraph 37? What is, and might you display paragraph 37, please? This is the AIHW. Does this include is this just the permanent and reserve members, or also includes the veterans in the consolidated database?
Mr. Connor, the AIHW report that's referred to there includes serving, reserves or correction, all serving members, full-time, correction. It includes all serving members, regardless of service category, and veterans.
So
Between the dates given, which is the 1st of January 85 and the 1st of January, correction, 31st of December 2019.
they, of course, are only the people who have died after 1 January 2001.
No, that's not correct. So there are two separate AIHW lists. There is the AIHW report from last year,
Yes.
which covers individuals who have served 1 day from 1985 onwards, but who have committed suicide, died by suicide since 2001. And there is the report that was prepared by AIHW for the Interim National Commissioner, which extends that event horizon back out to 1985. So it's those who have served 1 day since 1985 and who have taken their lives since 1985, which explains the difference of about 600 members between the publicly published numbers by AIHW in late last year and those that were provided to the Interim National Commissioner around the middle of last year.
Right. So there's another 600 now. There's another 700 or so that Dr. Boss seems to have identified. Is that correct?
Dr. Boss identified 648 individuals, and I do not know the methodology by which she identified those individuals, noting that Defence was provided her with a range of data sources to assist in the collation of her list.
I notice the time, Commissioners.
If I understand, we're breaking for lunch and then there will be a continuation of this panel for another half hour or so after lunch.
That's correct, Commissioner.
Okay. Well, we might break for lunch then and return in about half an hour.
All rise. The Royal Commission will now adjourn until 2 o'clock. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Mr. Connor.
Thank you, Commissioner. Brigadier, may I just clarify some things concerning the consolidated register and the four parts or four sources from which it's been built?
Certainly, Mr.
Sorry,
Certainly.
the AIHW numbers, you know that the most recent report, publicly available report, lists or totals 1,273 deaths by suicide, and that's the 29 September 2021 report. Have you information from AIHW or elsewhere that goes beyond that and has been included in the consolidated register?
Yes, Mr. Connors, and that was previously referred to in notice to give 1 to the Royal Commission.
And what are the additional? What covers the additional deaths? What are there deaths from 1985 to 2000? Is that what you've got from AIHW?
That is correct. So as the Interim National Commissioner commissioned a series of additional work that was undertaken last year, and as part of an information sharing arrangement which Defence entered into with the Australian Institute of Health and Welfare, we were able to access additional names and confirm that they are in fact Defence members. And that information was provided in an earlier notice to give.
Now, in data form and not otherwise. Is that right?
I don't understand that question.
You provided the data, the bundle of data, rather than the number.
No, we provided both the number and the names, Mr. Connor.
Now, may I return to a question? We've spoken of, on the one hand, primary information, as it were, and Mr. Morton, you've referred to various places where primary information might be, and it might be linking in some way, or at least discoverable from the Defence Suicide Register. And I've asked you some questions about whether Defence itself was carrying out an analysis or an assessment of individual cases, and you've given some answers. Now, what about systemic analysis of data and information in the Defence Suicide Database? Is Defence carrying that out?
Defence has carried out analysis of the Defence Suicide Database progressively to help us understand what might be obvious or occurring, or any potential trends or indications that come from the database that we have then used to inform certain actions that we've then put in place.
Now, is there some document or body of material that identifies what you have ascertained from your analysis of the Defence Suicide Database? And that, by you, I mean Defence.
I don't believe there is a single document that embodies that or presents it.
How many documents are we looking at then that does that?
I'm unclear, because I'd probably best describe it as a progressive piece of work in how we use the Defence Suicide Database and any other relevant research that might be conducted around suicide.
And you claim that that's a systemic analysis, do you, of the Defence Suicide Database?
No, I wouldn't claim it in that way. I'd say that that's the actions that we undertake that we think gives us an overview of information that we can then utilise in relation to the range of policy and programs and services that we try to provide.
So you'd be able to identify, Defence would be able to identify all the risk factors that it's identified and taken steps to take some action concerning risk factors.
I would endeavour to say that today I probably couldn't give you a list of all the risk factors, but I would certainly be able to identify a number. And
I'm really asking a question about what has happened in the past
Yes.
and whether Defence has done this. And I was saying that you could give us a list of what you've done in the past concerning identification of risk factors.
Yes, we could in terms of identification of risk factors, but also in terms of what action we've taken in relation to certain risk factors that we've identified. And also we could identify how above and beyond the suicide database, how relevant research in recent years has also both identified risk factors and reinforced our understanding of the risk factors we're seeing occurring through the Defence Suicide Database. So our approach has not been single focused, looking through the lens of only looking at the Defence Suicide Database. It has been quite a broad focus whereby we look at issues to do with suicide factors and suicidal behaviours.
Now, what to your mind is critical suicide risk factors that have come into your perspective?
So some examples would be
the most critical and descending down from your experience. And
so I would say that from the information that we have available through us in Defence, I would say the most critical tends to be we would see relationship status, we would see social connection as being a significant risk factor, the absence of social connection in some circumstances. We would see risk factors that relate to whether there have been previous suicide ideations or suicidal behaviour as being risk factors. And then there would be additional protective factors that we would identify as well, of which there'd be some examples also.
have you put this together in any particular document?
I believe that we have shared with the Commission in information that's already been presented or provided to the Commission our indications of suicide risk factors that we've identified from consideration of things like the Defence Suicide Database, but also the learnings that have occurred through research findings going back as far as 2010, and also more recent research that's occurred. We've also submitted that risk factors such as the ones you identified and put in front of me today from the previous reports that we've commissioned are ones that we've been alert to as well.
Now, identifying amongst reservists problems such as attempts at suicide, suicidal behaviour, suicidal ideation, and the ultimate tragedy of suicide. What is Defence doing about that?
In many ways, it depends on, it depends to some extent, so sorry, forgive me, what Defence is doing. Defence makes all of the information that it is available in relation to full-time serving members is available to those people who are serving in a reservist capacity who are engaged in regular service, full-time service with Defence. So there is, sorry.
I'm not talking about the provision of information to the people.
Right.
I'm talking about, asking you about the monitoring of these people.
Right. So
what is Defence doing there?
So Defence doesn't have access to information for certain people who would be serving as reservists, depending on the nature of the reservist service. So in actual fact, there'll be a number of categories that I think have been referred to earlier that there would be limits to the contact that Defence would have. Additionally, a number of reservists, depending on their service categories, would be getting none or very little direct healthcare services from Defence. So therefore, there's an avenue that we won't necessarily have available.
But how is Defence going to fix this?
So I think there are a number of activities. There is a if the problem that we're seeing, and the problem as I would see it from Defence's point of view, is we don't have access to a lot of information that might relate to a proportion of reservists, depending on how far away they are from full-time service, the distance from Defence. From that point of view, I think a view would be that much of the functions that were identified as being functions of what was the proposed interim National Commissioner's role, we saw that there was quite a lot of potential for information to be gathered by being able to access information sources that Defence does not have access to, such as coronial systems, such as external health systems that reservists may well be utilising, that may well be collecting information on how they're utilising healthcare and how they're accessing or how they're identified as having at-risk behaviours that may be showing up in the healthcare system but not in the Defence healthcare system. So Defence was of the view that in actual fact that proposal for such activity would occur would strengthen the opportunity to obtain and learn more information about populations, including reservists, who we may not have as regular information or as regular contact with as we would a full-time or permanent serving member.
Defence is not funding AIHW. Is that the case? Their work?
Can I just check, are you saying funding AIHW in relation to the work they're doing on suicide prevention?
Yes.
As suicide. Monitoring?
Yeah.
Defence, in fact, has agreed to fund AIHW for the remaining 2 years that they've currently got under agreement to do the next 2 years of monitoring.
Is that a new arrangement, is it?
I think it's a recent understanding that has occurred between Defence, DVA and AIHW.
And there's been a recent decision referred to in paragraph 100 of your notice to give. That's the Chief of Defence Force inviting a number of organisations to partner with and assist the Department of Defence in a research activity looking into the important area of suicidal behaviour.
This is a really exciting development because this actually builds on the work that Joint Health Command and Defence have been working on now for a number of years, that progresses to be able to achieve better understanding of suicidal factors and suicidal behaviour. And we've previously provided evidence to the Commission around that work through looking at suicidal factors. And additionally, what it enables Defence to do is it enables us to be able to start to broaden the focus from a consideration of not only what do we know about suicide deaths and the experiences of people who've died, but in fact to start to focus on looking at how does that align with contemporary information about those who are representing now with suicidal ideation or suicidal behaviours. And our task, what the CDF has invited organisations to assist us with, is to come in and have a look at how we can best design and develop an approach to get a better understanding of the suicidal factors that will allow us to apply that knowledge to those that are currently and most contemporarily presenting with suicidal behaviours.
This could have been done many years ago, couldn't it, Mr. Morton?
I don't believe it could, to be honest. No.
Now, Commissioners, might the Commissioners have some questions? I notice the time, it's 15 minutes before the end of this panel.
Thank you, Mr. Connor. Commissioner Brown?
Mr. Morton, I wanted to go back to the discussion before lunch in relation to what actions Defence takes to look at individual deaths by suicide. And what you were saying is that Defence takes action in a number of different places and then it kind of all goes up to IGADF. It did sound, however, as though it's a somewhat siloed approach. And I'm just wondering whether there is a reason why, for example, health, having looked at their systems, and command, having looked at the circumstances around an individual's death, and the chaplains and their colleagues, etc., might not all come together within defence as opposed to IGADF to do that individual review of a suicide death.
I would say that I think that is an area that Defence could further progress and develop in order to be able to achieve a more holistic view. And in doing so, it is important that we're able to take note of the range of different types of information that, one, are available and two, are pertinent. And I think the work that's been done over a number of years to help ascertain the types of information that might be relevant in relation to looking at suicide factors is at a stage where where that sort of work can be and could well be progressed further within Defence.
Well, that's good to hear. Can I just also ask, perhaps not given that you don't currently do it, could I ask, you did talk about this Defence Suicide Database not necessarily including information from families because you don't interview families.
Yes.
In your view, should it contain information from families? Would it be beneficial for there to be a process for families to be interviewed and for such information to be captured within that database, or indeed one of the other databases?
I'm unclear at this stage that there would be a benefit for including such information in the Defence Suicide Database, but I'm not unclear about the value of such information, and that such information could assist to provide a more holistic picture of the circumstances. The observation that I would make is that area of work to identify the range of information that one would seek, the manner in which to do it, is work that, in my opinion, has been emerging in the broader area of suicide prevention and mental health and wellbeing in most recent years. I think we've got some extremely good guidance that's been provided by the National Suicide Prevention Advisor around the process of journey mapping, which I think itself has a lot more potential outcomes, and that would actually go to being supported by the sort of work that CDF has agreed that we would now proceed with. So that's one of the reasons why I suggested in an earlier response there that I don't think some of these things could have been done earlier. I believe that work will be very valuable, and I think it will be of assistance. I think the other thing for us to bear in mind is we should not make an assumption about the way families want to be engaged in relation to discussions around suicidal death or suicidal behaviour. And we need to do that in a very nuanced and sensitive way. And it doesn't lend itself to just be captured by the whole focus on a discussion around a database. It actually lends itself to the area of lived experience and lived experience approaches, which is the other area that Defence is working to further develop. And additionally, it goes to the issue around how risk assessments are approached, and therefore the work that Defence is currently doing on looking at trying to implement a safe side recovery-oriented approach goes to looking at the issue of how do we engage families in that process as well. So that's one of the other reasons why I think certain things could not have been done earlier, given the development of some of these approaches, the work of people like the National Suicide Prevention Advisor and the advice that was put together. And I think also the capacity of a system like Defence to capture and engage with all of the relevant information, some of which is outside of Defence's authority or capacity to actually engage or have ownership on. It's not to say that we shouldn't be interested, it's not to say we shouldn't go to families to talk about that, but we do need to be mindful of making sure that we do that in the most effective way. And that's the bit that I think continues to need to be developed.
Sure. Could I ask the Brigadier a question, just in relation to the consolidated register? Can I just ask whether that contains all deaths of ex-serving members of the ADF?
Thanks, Commissioner. It's our intention to capture all of the ones that we become aware of. It's particularly difficult for us to identify veteran deaths. So for veteran deaths, we're primarily reliant upon the great work of the Australian Institute of Health and Welfare. On occasions, we are flagged by unit associations, ex-service organisations, families who ring up and provide us information. And so it's certainly not definitive. It is updated, on occurrence. So we have a number there of what we were tracking as of last week. I'm certain there's been some additional ones perhaps coming over the weekend that we'll now do our due diligence on to confirm whether they were in fact a service member. Do we understand anything about them? Can we collate their records and then pass them through to you in a subsequent tranche, Commissioner?
So sorry, just so that I understand that really clearly. So the number you've given us is very recent, but as far as you're aware, does that contain all ex-service members, all ex-serving ADF members up to at least 31 December 2019?
It does between the years 1985 and 31st December 2019 based on the great work of the AIHW. Now, there may be additional ones which have come to light or have occurred since that period. We will have captured some of those, but it's only when that information has been able to be brought forward to Defence because there is no national level mechanism to actually capture that.
And you don't necessarily have ex-serving members who died prior to 1985 either, even though the register starts at 1970.
So the earlier names are predominantly based from the Joint Military Police lists. There are almost certainly more names. There may be some on our register which have been flagged to us by families or ex-service organisations, but in no way, shape or form is the list definitive, and it will continue to be updated as we uncover additional evidence or information, Commissioner.
Thank you.
Thank you. Commissioner Douglas?
I'm interested in the difficulties you say exist in respect of getting figures of those who've died by suicide from people in the reserves. As I understand it, you have people in the active reserve and on the inactive list. I can understand the evidence about those on the inactive list, but I would have thought it would be pretty easy to find out whether somebody who's in the active reserves has died by suicide or not. Maybe Brigadier, you can answer that, or?
It cuts to the question, Commissioner, of the various service categories. So service category 5, where a member is a member of, essentially what previously we would have called the active reserve, and are regularly parading and are in a formed unit, yes, we will identify those quite rapidly. It's some of the other service categories which are formed by legislation, such that, for example, if I was to leave Defence tomorrow, I would remain on the as a service category 2 member, so inactive reservist, as it were, for a number of years, even though I might have no contact with Defence, I might wish to have no contact with Defence. And so for that particular category and service category 3, it's more problematic.
Okay, but is what used to be called the active reserve service category 1?
What you would call the active reserve would be service category 3 and service category 5. So, service category 5. Service category 5 are formerly reserve members who parade with a formed unit and have regular interactions with Defence. Service category 3 are more those who provide contracted service for a period of times, either on projects or to a unit or for a particular purpose. So if they were actually on contract, we would probably pick those up fairly quickly. If they were not on contract and had not been for perhaps a number of years, there's no reason for us to be able to identify that they may have taken their own life or died perhaps by any other means. Commissioner.
But if you were given, say, through coroner's offices, names of people who have died by suicide, you should be pretty readily able to discover if they're former defence members.
Absolutely, and that's where
AIHW
work is fantastic in helping us do that. And certainly I'd say from, and that's why that annual report is so important to us to actually be able to consolidate our information, Commissioner.
Thank you.
Thank you. Two very quick questions, simply for clarification. They probably refer to Mr. Morton. You've mentioned a couple of times that the decision to invite partners to assist Defence in research activity couldn't have been done many years ago, despite other research that's come out of Canada that we've discussed and other places. I'm still not clear why you don't think that could have been done earlier. You just press the button.
I'm sorry. I think what I'm referring to there is that I don't think a combination of things had come into place a number of years earlier. I don't think we had an e-health system that is that enables us as clearly to identify people in terms of presentations of things like ideation and planning and that sort of suicidal behaviour. I think I believe also that some of the identification of factors that need to be taken into account have emerged over a period of time. I would recognise that some of the information that you were seeing in the AISRP report that was referred to earlier, we were able to identify the range of factors that were clearly obtainable at that stage. Some of those will have become more so over recent years. I also think that there has been an increased focus in the suicide prevention area and the mental health area on the importance of being able to have a look at suicidal behaviours as early as possible. And we've looked to undertake research that will help us identify how people are presenting to health services without even talking about suicide, that starts to pick up some of the conditions or the symptoms they're presenting with that could be indicative of trajectory. Now, our knowledge of those things has only come about as a result of the research findings that have come through such research as the 2015 Transition and Wellbeing Research Program, which we reported on, and
6
also
or
the
7
laser
years
study.
ago. A lot of these things are 6 and 7 years ago. The Canadian work is about 10 years ago.
I accept the issue about the Canadian work. I can't offer you a different solution to a different view on the Canadian work, but I do recognise that a number of the factors that we now and the knowledge we now have around suicidal ideation have progressively been developed. I would just say it's my opinion that for a range of reasons, such work was much more difficult to undertake, say, 5 years ago than it is now, given what we know and given what sort of information is now available.
Thank you. One final question, and again, Mr. Morton, sorry to load you up. I'd be grateful, if at all possible, for you to answer this question with a yes or no answer.
Sure.
Does Defence have a central area that gathers all of the known data about suicides of serving members and conducts analysis of that data to look at causes, factors and so on?
No, there is no one area.
Thank you. Commissioner Brown.
Sorry, just an additional question. Does Defence have a way in which it looks at the data of around ex-serving members to understand whether there are factors relating to their defence service that may have contributed to death by suicide of people after they have left the Defence Force? Because it seems to me at the moment that's where there is a bit of a potential gap, that we have some avenues for looking at defence suicides, albeit that we may think there are some issues there, But the ex-serving, it's not entirely clear that anybody's really looking at them outside of the AIHW. So I'm just wondering what Defence
Yes,
might do in
so there are
that space.
two areas that are identified. One is the information that has been coming through the AHW reports over the last few years is a source of that information. The other area is the activity that has just been mentioned, and that is the research that we've just got agreement from CDF to invite expert groups to come and help us with, because what we're looking at trying to achieve there is an examination of contemporary deaths of serving members, an examination of the most contemporary deaths of ex-serving members, utilising the work that DVA are preparing in what they're referring to as their adverse event unit, and also incorporating into that information about contemporary presentations to the defence healthcare system of people who are presenting with suicidal behaviours. And what we're looking to do is to design some work with the experts in order to help us look at those, to help us identify the factors that would look at serving, while they're serving, after their service, what has moved across with them or in related to that, but additionally, what's occurring in relation to suicidal behaviours for that group.
The challenge with that, Mr. Morton, I accept what you're saying, but the challenge with that is that even the data sources around the ex-serving is still incomplete.
Very much
The DVA adverse events analysis is predominantly looking at the interaction between the ex-serving member and their systems, and the other one, and I can't even remember now what it was, but it's again an incomplete data set. Not all ex-serving have contact with DVA.
I don't suggest at all that I'm underestimating the challenges that are in that area. Just to describe that we've identified that in the work that we do, we need to be looking at a consideration of applying these considerations to ex-serving, but we recognise there are challenges in being able to look at it, which is one of the reasons we've approached a broad range of organisations to help advise on the design and the development of approach of looking at this. I'm not suggesting to you I have an answer to that at the moment.
Is one of the questions in that consideration, how can we better collect the data around all ex-serving?
It's one of the considerations that will be put to the group to help us understand if there is a way of doing that at the moment or what needs to be done to achieve it.
Thank you.
Thank you. Mr. Fordham, anything to raise?
No, thank you.
Mr. Connor, any matters arising?
No, Commissioner.
Okay.
Might Captain Kerr and Brigadier Lenihan be released from their summons? Mr. Morton will be present on Wednesday.
Okay. Thank you, gentlemen, for your evidence today. Mr. Morton, we'll see you again. And the other two witnesses, you're excused from your notice to appear today then. We'll adjourn for a very short time.
All rise. The Royal Commission will now adjourn until 2:40. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Commissioners, this is the Information Sharing and Access Panel. Today here from DVA, we have, starting at the left, Ms. Rachel Goddard, who was the First Assistant Secretary, Transformation and Commemorations Division. We then have Ms. Maura Campbell, who is the Assistant Secretary, Client Access and Rehabilitation Branch. And from Defence, we have next to her Air Commodore Steve R. Martin AM. We then have Ms. Monique Hamilton, who was the First Assistant Secretary, Service Delivery. And finally, Dr. Tom Clark, First Assistant Secretary, Enterprise, Transformation and Governance. Can I formally ask that each of the panellists be affirmed and sworn in, or sworn in?
Dr. Clark, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Monique Hamilton, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Air Commodore Martin, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Maura Campbell, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Rachel Goddard, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Operator, can we please display the tender list? Commissioners, on this tender list, the documents shaded in blue are documents over which claims of confidentiality have either been made in whole or in part and which have not been resolved. I tender these documents subject to those claims. Panellists, and just very briefly, starting from left to right, can I please ask each of you to just briefly identify your current role, when you commenced in that role, and your prime responsibilities for the commissioners?
So Rachel Goddard, my current role is the First Assistant Secretary for the Commemorations and Transformation Division. I've been in this role for approximately 2 years, with commemorations coming in about this time last year. Sorry, what was the rest of the question?
Sure. Well, it's just really just a little bit about yourself. So your role, your primary responsibilities.
So I'm responsible for the acknowledgement and commemorations of those who serve in Australia and allied wars, conflicts and peace operations. And I'm responsible for the delivery of the Veteran-Centric Reform Transformation Program in DVA, a number of other ICT delivery projects and the Enterprise Program Office.
I'm Maura Campbell. I'm the Assistant Secretary of DVA's Client Access and Rehabilitation Branch. I have been in the role for almost 8 months and I'm responsible for a range of functions in that role. They include service delivery in the form of our frontline staff in Veterans Access Network responding to general inquiries made by our veteran community and their families. I'm responsible for program management for DVA's rehabilitation and medical and allied health arrangements, a range of claims for payment, primarily for medical and travel expenses, a centralised role for DVA's client feedback management function. We are responsible for coordinating responses to the Commonwealth Ombudsman, and finally, we process all of the department's statutory information access requests and some of the more complex administrative access requests.
Thank you.
Air Commodore Steve Martin. I'm Director of Special Projects within People Capability Division. I've been working in this space for the last 11 years. predominantly in information sharing initiatives and some of the governance arrangements, including the development of the current MOU and some of the schedules.
Thank you.
I'm the First Assistant Secretary for Service Delivery Division in Defence and have been in that role since June of 2020. The role is responsible for large-scale delivery of facilities management and base services across the Defence estate, as well as the customer service network, which encompass a range of corporate services, including travel, publishing, libraries, Defence archives, and the customer service network across the country.
I'm the First Assistant Secretary, Enterprise Transformation and Governance in the Department of Defence. I'm responsible for the governance arrangements for the Defence Enterprise, including its records management policy framework, as well as the Defence Transformation Program. I've been in that role since June of 2020.
Thank you. Operator, can I please ask that you display document ID DEF.009.005.001? Now, this is Defence's response to the notice to give DEF 004. Can I ask those panellists from Defence, did you each provide the information or instructions which formed the basis of this response?
No.
No? Which of you did?
No.
None of you did?
No.
Have you seen this response before?
Yes.
Do you disagree with any of it?
No.
No. So you accept what's in there as being accurate? Operator, can I please ask you to display document ID DVA.quadruple9.0006.001? And this is DVA's response. So Ms. Goddard and Ms. Campbell, I'll ask you the same question. Did you provide the instructions or the information which formed the basis of this response?
For part of it, yes.
For part of it? And do you recall which part of it, or?
Actually, the majority of it. Question 5, I did not provide any responses to that and a couple of the other paragraphs, but other than that, the majority came from me and my team.
And have you both seen the response?
Yes.
And do you accept it as accurate?
Yes. Yes.
And are there any changes you'd like to make to the response at all? Panellists, today I'm going to ask you about 3 primary topics, and I'll introduce those. They are information sharing between Defence and DVA about current and former Defence members, information sharing by Defence and DVA with families of deceased members, and finally, information sharing by Defence and DVA with current and former Defence members. Now, I'll let you know when I intend to move on to another topic, but depending on your answers, I might just flag that there may be some overlap in those topics. And in terms of answering the questions, I'm going to be largely guided by you because I'm not entirely sure what each of you know. So if we move to the first topic now, which is information sharing between Defence and DVA, I understand from DVA's response that in terms of that information sharing arrangement, there is a memorandum of understanding that exists between Defence and DVA, which was entered into on 5 February 2013. Is that correct?
That is correct.
And am I correct in saying that the only relevant schedules in terms of information sharing between Defence and DVA are Schedules 17 and 20 to that MOU?
I think that's correct.
I think that's correct.
Now, I understand that a coordinated single point of contact approach has been adopted in terms of how DVA requests and receives information from Defence, and this is commonly referred to as SAM, which is an acronym for Single Access Mechanism. Is that correct?
That's correct.
So can you please explain for the Commissioners how information is shared through SAM? What's the process within DVA? And then I'll ask the same of Defence.
So either a delegate within DVA or a registration, it may be a registration or screening officer, will identify that information is required for a claim that is held by defence. They will ask for the relevant information through our ICT system that will go through to our SAM team. So our SAM team coordinates that request with defence, or they may self-service that request.
Okay. Can I ask, how does DVA determine what information to request from defence?
So that comes down to what's required by the claim. So generally it would be service information, HR information, information about a veteran's medical condition or health.
So it's claim specific?
Yes.
And is the information that's then shared, is it limited to records and information that are just simply required in connection with a DVA claim?
Sorry, can you ask that again?
Sure, yeah. Well, I'll ask it maybe just in terms of what records are commonly shared through SAM.
Mm-hmm.
What are the types of records that are commonly shared, or the types of information that's commonly shared from defence to DVA?
Thank you. So generally it's information around a veteran's circumstances, so general demographic information. We also share information around their service history. We share information around their medical history. We also share information around incidents that might have occurred where they may have been ill or injured. That would be predominantly the information that we share.
Okay. And is information shared with DVA through any other channel, or is it always through SAM?
So generally the information around claims comes through our SAM team. We also have an early engagement model where we also share information with defence, and we also receive information from defence through our My Service web connection as well.
Can I ask, what information do you share with defence?
The information we share with defence is generally related to when a veteran lodges a claim, we provide notification that claim has been lodged, and when that claim is determined, we provide notification that that claim's been determined.
Is that the extent of the information that you share with defence?
To my knowledge.
In terms of the process then, how long does it normally take to get a request to defence for information?
I couldn't answer that question. It would depend on the type of claim.
So it would be claim dependent again, depending on which statute the claim is made under, or how complex it is, or?
No, it would depend on, I guess there would be a number of factors. It would depend on the claim when it was received by the SAM team, how complex that request was, and also how busy the team was at the time.
Air Commodore Martin, I saw that you wanted to perhaps answer us before. Did you have something to add?
As you imagine, this is a two-way street. Requests from DVA received by the Defence SAM team. Two SAM teams work very closely together, as you would expect. Once received, the request is quality assured to make sure that all the information that's required for us to be able to answer the question, and the question is clear. And then the request is triaged, and depending on where within Defence that the response needs to come from, the request is sent out, response comes back, and again is quality assured to make sure that we're actually answering the question, and then the response is provided back to DVA. Under the system as it currently stands, the Defence SAM team is able to source about a third of the information that goes to Defence themselves. About a third of it would come from Defence Archives, and the other third would come from a range of areas right across Defence. And then it's passed back to DVA. But it is one element of the information sharing arrangements with DVA.
What are the other elements?
As my colleague mentioned, My Service is an application within the DVA ICT environment, which lets members log on. It is linked to Defence, our PM Keys, the personal management system. and will pull out a set of agreed data sets to help validate the client and certain service details, including their qualifying service. Defence has also provided select DVA staff with direct access to the PM Keys system, to our Work Health and Safety Incident Database, and to the Defence e-Health system to allow DVA staff to self-service in a way of trying to speed up the flow of information between the two departments.
Yeah, so when you say self-service, you mean DVA can just simply access a member's or former member's records within Defence, so they don't need to make a formal request?
Correct.
And what type of does that include medical records, for example?
They have direct access with caveated control into the Defence e-Health system to allow them to access an individual member's records in response to a claim. All their direct access is based on DVA staff having a need to know and a legitimate basis to do so, either under the legislation or the member's consent.
How is that monitored?
How is that monitored?
Yeah, so in the sense that, sorry, I'll just stepping back. So if you have a DVA officer determines that they need certain information for a claim,
yes,
there's certain information that they can directly access
yes,
through My Service.
Yes.
And on the PM Key system within Defence.
Yes.
Yeah. What are the limitations in terms of that access then? Like what types of records can they not access on that system?
They can't access anybody with protected identity.
Anybody, sorry?
Anybody with a protected identity. But their access is, when they're granted access, their access is to specific data sets. Now, I can't tell you exactly what's in each of those data sets.
Right.
But their access is granted for certain data for certain reasons.
Right.
And that is set out in the schedule to the MOU.
But the type of information that they could access is, for example, the medical information that they would require. And if they can't get it, they would then lodge a formal request with.
If they don't have a legitimate basis to do so, or the member has restricted or caveated their request, then it would be a SAM request.
Okay.
And Council, if I could just add, in terms of self-serving to records, those that are not yet digitised, so dating back, not all records are digitised. We are going through a program to achieve that. Currently, around 17 kilometres of 65 kilometres of records have been digitised. So at the moment, around 27% of records that are required by DVA are digitised and available to them to self-service.
Right.
The remainder, archives need to recall and digitise.
So in 27% of cases, roughly, I won't do the specific thing, but
We're at 27% of all personnel and health files today, and we expect to be at 40% by the end of this year.
And when do you expect to be at 100%?
I think the timeframe is currently 5 years, noting these files date back some time. The paper is not all uniform. It has faded over time. The state of the files is varied. So it takes on average 7 hours to digitise a member's file. Where they've served 30 to 40 years, it can take upward of 20 hours to digitise a single file.
Okay. Sorry, Air Commodore, you mentioned before that in terms of that My Service access, you said that provided that a member hasn't restricted?
No.
No.
If they're directly accessing our records, so if they've got to log on to the personnel system or to the incident database or to DES,
yes,
that's what I was referring to there.
Right.
My Service is a fully electronic connection. The DVA system will poll PM Keys.
Yes.
PM Keys sends the answer back on an individual case basis. There is one other element of the information sharing too that a colleague from DVA mentioned, and that is the early engagement model. Defence routinely tells DVA when a member enlists in or appointed to one of the three services. If they're involved in a serious incident where a medical classification of seriously ill or very seriously ill or injured occurs, when they're given a proposal to terminate their service on medical grounds or for any grounds associated with the use of prohibited substances, or when a decision is made to terminate their service administratively where alcohol is a significant contributing factor, when a member transfers from permanent service into a reserve service, and when a member separates from the ADF completely. The enlistment, transfer and separation notices go in bulk every fortnight by email as a spreadsheet. The other three are individual case-by-case notifications made by the Defence Member and Family Support Branch for serious incidents and the career management agencies for the other.
So there are some categories of documents in certain cases which are provided automatically to...
The early engagement notice are limited in the information. It's mainly contact information, a little bit of service history. The intent of the early engagement model is to establish a relationship between DVA and the member as early as practical in their career. And so from 2016, that's been everybody who's joined the ADF since that point in time. When they transfer from permanent service or when they separate from service, and that helps facilitate the issue of the non-liability healthcare white card, and in all circumstances allows DVA to keep members informed of the support that's available, and for the medical or drug or alcohol separations or serious incidents, it gives DVA the chance to see what support the member may need should they wish to make a claim.
Are complete medical records ever provided just automatically? For example, if a member is transitioning for medical discharge, or let's say a member is medically discharged, do their medical records just automatically get sent to DVA?
No. Medical records are only provided when they're requested.
What are the other limitations, and in particular, are there any legal limitations that exist? For example, is some information sometimes not released to DVA for privacy or other reasons?
Yes.
Or information sent over that's redacted?
Yes.
Yeah, and can you explain to me the circumstances when that would arise?
I'm not involved in that. My colleagues but where third-party information, operational information, would require the files to be redacted.
Is it just operational information, or is it? So you said third-party information. Is that just broadly concerning information
where a document includes details of individuals who aren't part of the claim?
Right. So their names and everything else will be redacted.
That's my assumption, but I'm not involved in that process.
Right. Okay. Does anybody know on the panel
I'm
the
not
types of
involved in
redactions that are applied?
transfer of information to DVA.
That's okay. Can I ask what you mentioned before about the claims, and you provide notification of claims, I believe, and determination letters, I think was the other thing. What does Defence do with that information?
That's not a question that I can answer.
Can answer. Okay. Operator, can you please display document ID DEF.1019.0001.0705 at .0709? And display table 1 on that page, please. So it's 0709.
17.
So this is Schedule 17
Thank you.
to the Memorandum of Understanding, and these are the time frames that exists.
Yes.
Can you please explain to the Commissioners the different time frames that apply for each of the categories that are mentioned there?
Okay. Sorry, as part of the prioritisation process to allow us to focus on requests as they come in an appropriate order, the DVA classifies or categorises the request against this table.
Right.
And that gives Defence then an understanding of how to triage the requests and the time frame which we aim to try and get the responses back.
Okay. So that's a DVA classification,
Correct.
urgent,
Yep.
complex, medium, routine.
Yep. They are agreed between the teams.
Yes.
But only DVA can classify or categorise a claim.
And can I ask DVA then, Ms Goddard or Ms Campbell, how's that assessment made within DVA as to whether somebody falls within one of those categories? What tests are applied or what information is sought?
I'm sorry, I can't answer that question, but we can provide that information.
You can provide, okay, thank you. And Ms Campbell, I guess you can't answer it either?
I cannot, sorry.
Can I ask then, and I suppose then you probably all also can't answer, well, perhaps you can. What about requests for information that require an immediate response? And the example I'll give is where a client is, or a member is identified at being at risk of suicide.
You'll note that Part H has a special provision. The benefit of the two teams working closely together, if there is an issue, it's urgent critical. That will be dealt with outside the system as in response to the need.
Okay, so to just be as quickly as
correct,
humanly possible. In terms of the timeframes that are identified there, typically are those timeframes met?
Not always, and the answer to that, the reason behind that is it depends on the question, and it depends on the availability of the records. The more recent and the more easily available the records, the more often we will meet the timescale. But some claims require significant research to determine if the information sought even exists, and also where it requires redaction or that will take additional time. And also there are times when some of the requests require a defence delegate to exercise their judgment or make a decision in response to the question. How long would a trooper continue to get a Special Forces allowance if they hadn't been injured? That requires a CDF delegate to make a decision, and that information is then used by DVA. So it's how long's a piece of string? To give you an indication, if I put it in context, in first quarter 2013, Defence provided responses to just over 3,100 requests. 35% were within the time limit. So there was a lot that were longer than that. In the last quarter of 2020, which is the last data that we hold at the moment, Defence provided responses to nearly 6,100 requests. At 75% of them were within time. Financial year 13-14, we dealt with 17,000 odd requests. This year we're on track to probably hit about 45,000 requests. So in the intervening years, the requests have gone up 260%. But we've doubled halved the response time. We've doubled the amount of responses that are actually within the time limit. And in that quarter, there were only 36 urgent requests out of over 1,000, so about 8% of the total that were outside their time limits.
Can I ask why? I'll ask a few questions. Maybe the first one is, you said it depends on the research that needs to be undertaken to determine if the information even exists. I gather from that there's no sort of central repository of information within Defence where these records are kept. They're all kept separately or under different departments.
It depends what you're asking for. In preparation, one of the examples I was given, and again, I don't work in this area, but I have a reasonable working knowledge. The request for information was for Something that happened on the member in 2020, the DVA request was to provide, if we could substantiate or provide evidence of a member's exposure to a traumatic event in 1976. So extensive research was done, both inside defence and using records outside defence, and we were not able to ascertain a connection.
Right.
A subsequent request a year later in 2021 returned the same thing. Army subsequently came back and advised us that they had eventually realised that, or not realised, they had determined that the incident in question had happened 2 years earlier than was specified in the claim, with a different name, but there was no record of the claimant's involvement. So there's a lot of work that goes into some of these claims, and that's probably at one end, but there will be a lot of records that go back quite a long time, take time to find because most of them are paper-based or require confirmation of a member's particular activity, which may or may not have been recorded.
But those paper-based documents, they're being put into the electronic system?
If the paper-based are being archived, yes.
Yeah.
So we hold in Defence Archives corporate records, we hold health records from World War II till 2014 when the e-health system commenced. We hold personnel records from World War II to current and psych records from the 1950s to current. That's our holdings. There's over 130 kilometres in total, 65 of that relate to health and personnel files. We prioritise our digitisation schedule each year based on where we know the bulk of requests will come from. So that's why over time more and more is readily available at the time DVA or others request it, as opposed to us having to recall it and then digitise it once the request comes in.
And remember too that, correct me if I'm wrong, but just because we digitise a paper file from 1970s doesn't mean it's easily searchable.
I suppose that's why, just in terms of what you've just explained, why the longer someone is separated, the longer it takes to respond.
Correct.
Yeah. But the aim for a routine response, though, if I'm right, is 35 business days.
That's correct.
Yeah.
Yep.
So in DVA's response, it's at a particular paragraph there, I won't bring it up, but it says that the current SAM arrangements use 5 different and unintegrated applications, making management and tracking of requests and responses to DVA difficult. Now, I understand that there are some things that are being taken to improve that, but what are they?
So from a DVA perspective, a lot of our systems are not integrated, and so therefore seeking information from Defence does involve a number of systems at the moment. The process that the SAM team use, as my colleague mentioned, there are a number of systems that we can self-access, and there was also the request management system where we ask for the information. So what we are doing in that space to, I guess, bring that together is a project called the Defence DVA Electronic Information Exchange and the request management system. We're making significant improvements to those systems, or introducing what we call the DDEIE system, that exchange system. The objective of that is that it will actually streamline the provision of information. So the request management system will make it streamline the request from the delegate or from the registration officer straight through to Defence to receive that information, or through to our SAM team. And the other way as well with DDEIE, a lot of that information can be pulled directly through the DDEIE system straight back to the delegate or through to the screening or registration person.
And when are those projects meant to be actually implemented?
So the RMS system was partially implemented in March last year, and has streamlined some of the connections between Defence and DVA and the way that we share information or exchange information around requests. The DDEIE itself will be introduced. We anticipate a release date in May this year.
And are those all the steps that are being taken to improve those systems?
Sorry.
Are those all the steps that are being taken to improve the information sharing arrangements between defence, the improvement of those systems?
At this stage, yes, the projects, the self-service of PMK, the service history and incident will be automated. The request management system will provide a fully integrated solution, which will also provide automatic access to health files that were digitised under a separate project. There was a 3.5-year project that digitised the health records of serving members. We know that those records, so if they're requested, the new system will automatically send that file back to, or those files back to the delegate requesting them, so further expediting the transfer of information. The information that we provide in the early engagement notices will go from a spreadsheet fortnightly to a electronic advice nightly. And the last one is the one feed that comes back to Defence will be data sets for claims and their resulting determinations, which will be go into the health knowledge system within Joint Health Command for use by Joint Health Command and the 3 service career management agencies.
Okay, thank you. I actually wouldn't mind moving on to the second topic, and I'll just focus on defence for the time being, because I understand the DVA have a very different arrangement that exists here, and that's information sharing with families of deceased member. So I'm right in saying, I think, that the Privacy Act doesn't apply to the personal information of a deceased person, does it?
In releasing records to either ex-serving members or their families, we do apply the Privacy Act in terms of redacting third-party information.
Yes.
And also potentially redacting or removing anything that may be sensitive from a defence operations perspective.
But can I just ask about the process then? Just in terms, as I understand it, there's an administrative release and also a freedom of information release that can happen. If a family member makes a request for a deceased member's records or information, is there any reason then, given that the Privacy Act doesn't apply, that that information wouldn't just be administratively released to them?
So I might start and then hand to Dr. Clark. If Defence Archives receive a request for a deceased member's records, we need the death certificate, and then we need proof of relationship. Again, the death certificate may provide that, or other documentation, birth certificates, marriage certificates, and so on. So once we receive,
can I just stop? So just stop there. So for the first step, then in obtaining the information would be establishing that you're a family member.
Yes. So they need to give their own proof of identity, yep, which is in line with the national policy, and then prove the relationship.
Yeah, and when you say relationship, how direct does that relationship need to be in terms of a family? So a spouse would qualify, a mother of a deceased
spouse,
veteran, a father,
parent, child,
sibling.
I couldn't answer that. I would have to come back to you.
Okay, but child as well could also seek that information. And from whom do they seek that information?
So if they come through the administrative process into Defence Archives, they complete the form that is available on the website and provide the evidence, proof of identity and proof of relationship, and then that request is managed. Our KPI is 30 days in line with the privacy policy, and aside from periods of bulk request, like for the Royal Commission, we meet that KPI. The record is then released to the requesting next of kin on a USB stick that is encrypted, password sent separately. They can also request it in hard copy if they don't have access to the relevant ICT equipment.
So Can I just clarify though? It's not a request that's necessarily made under the Privacy Act, is it? Isn't it just a request for information that you're administratively releasing to a family member?
We've lost.
Okay. The request is made through the form, but we do need to apply the privacy policy in releasing those records. So if Defence Archives are releasing those records directly, we redact the file in terms of third-party information.
Mine's gone off to operational information, those things as well.
That's correct. If we are releasing it internally to another part of Defence, whether that be for freedom of information or for Defence SAM to provide to DVA, we provide an unredacted version and they apply the redactions in terms of that release.
Just in terms of that then though, so is that that's all through Defence Archives? So a family member would contact Defence Archives would ask for the relevant information, and then that would be then provided as of right, really, just apart from the redactions.
Correct.
Is there any information that's excluded from that? Apart from operational secrecy, those sorts of things, and third-party information, so information about other people, you can otherwise obtain a complete set of records?
Yes, and
medical records?
So medical records, Defence Archives manage up until 2014 when the e-health system came in. If we receive a request for the health file and we hold part of that, Defence Archives will redact the component we have and release it, and then refer the request on to Joint Health Command for the information held within the e-health system, and Joint Health Command manage that request from there.
And are those the only limitations then?
From Defence Archives, yes.
From Defence Archives. But does that allow, what records are not able to be accessed through Defence Archives or through that process?
Defence Archives hold health records up until 2014, personnel records from World War II to current, psych files from the 1950s to current, and they are all available, provided the requirement for proof of identity and proof of relationship as well as the death certificate are provided.
So in terms of the redactions, how is consistency in those redactions achieved across Defence and those records? Is it the same team that kind of does it, or?
When we're releasing records to next of kin, we have a team in South Australia that manage those requests to maximise consistency. We do have well-documented policies for our service officers to follow as they're redacting files.
Okay. So is it beneficial in certain circumstances for people to request the information, or family members to request the information under the FOI process?
I think often family members go through the FOI process either because they may not be aware that they can just make the request through Defence Archives, right, or sometimes they are of the impression they will get an entirely unredacted version if they go through the FOI process, but they would apply the same redactions.
Okay. That's what I was going to ask. In practice, in what Defence does, they apply the same redactions no matter which way the request is made.
Correct.
Council, if I may, in terms of the Freedom of Information Act, its redaction requirements are set out within the legislation itself. Typically, the outcome for a family member seeking the personal information about a deceased member, if they pursued that through the Freedom of Information process or through the administrative process, would be the same. The only complexity is that the Freedom of Information process is much more formal, it's much more structured, and it generally takes longer. There would be some limited circumstances where there may be a different outcome because it's a different standard being applied. It's a legislative standard as opposed to an administrative standard.
When you say, sorry, can you just repeat that last part?
So, for example, in the release of information relating to a third party, there is the provision within the Freedom of Information Act for that information to be released if the third party consents to it.
Yes. Okay. No, I understand. I saw the legislative standard. Thank you. Just in terms of, I might ask, yes, in terms of personal representatives though, it sounds like there's no difference in the information that each could obtain. Am I right in saying that?
Yes.
Yep. So whether a family member is a legal personal representative or not, it's the same information.
They have to go through the same process of proof of identity, proof of relationship, or authority to act on behalf of a family member.
In terms of, actually, I'll ask the operator. Can the operator please bring up doc ID DEF dot 999 dot 0005 dot 0001 at 0006. This is page 6 of Defence's response to the notice to give. And it's a table that Defence has provided, and there are little ticks and crosses as to whether somebody can obtain information and the type of information that's provided. You'll see there in that third column it says families, and there's a tick, and that's an internal request to the chain of command. So this table seems to suggest that a family member can obtain information about a deceased member from that former member's chain of command. Is that correct?
I can't answer that question.
And that's, well, just don't know? Don't know how that process plays out?
I'm just simply not familiar with that process.
And it's because
I can say that Defence Archives do receive requests from the service groups for records, so, but I can't answer.
Yeah, no, but this is an internal request to the chain of command, so I wanted to ask some questions around that, but you don't have any knowledge about how that process plays out? No. Air Commodore, you're the same?
No, I have no knowledge. Also, we've lost our screens.
Yeah.
I think you have a printout.
Sorry?
I think you have a printout of this in front of you. No, thank you. In terms of support, are family members provided with any advice or guidance about the processes that they can follow and the options that are available to them to access information about deceased members?
I'll start, and I might hand over to Ms Hamilton. As of the 15th of February this year, we have introduced a process whereby family members who are seeking to appear before this commission can access through the Defence website, provide some basic contact information about themselves and the individual about whom they're seeking information. We will respond to that request within one working day, and a human being will talk to that family member about their information needs, to clarify their needs, to outline the various pathways that are available, either statutory or administrative, and direct them through the process. We'll outline also the pros and cons of the different pathways, depending on the nature of the information being requested, and then can, if the family member wishes, assist them in making that application through the process to conclusion.
Yeah, but I think you're talking there about people who are participating in this Royal
Indeed,
Commission,
and
I think what you're referring to there is the policy that has recently been adopted.
That's correct.
But I think it's at the instigation of these commissioners.
Indeed.
Yeah.
Sorry, if I can just interject there is an issue, and we had, it's really just making you aware, Dr. Clark, the requests that have come from us, I'm sure there is an awareness of what has been happening at the Royal Commission.
Indeed.
And there is an issue where a number of families have approached us because they cannot get access to material in relation to their loved ones. The Royal Commission is in a position where it obtains information using its coercive powers from government departments, but then we are unable to share that information legally with others. I hope there isn't a misunderstanding, and I need to clarify this. The requests that have come from us and the dialogue that has begun between the Royal Commission and the two departments, and the Attorney General's Department for that matter, is not simply about those who are engaging with the Royal Commissions. We are looking for a solution beyond that forevermore. If you can just please bear that in mind in your answers.
Yes, thank you.
Thank you.
If I can add then, from a Defence Archives perspective, through the Defence website. There is information on how to obtain records for either ex-serving members or for their families. Defence Archives have also produced a frequently asked questions brochure, and we make that as readily available through RSLs and similar. So we do have that information available.
Outside of the Royal Commission, though, if somebody calls Defence Archives, do you then spend the time with them to talk them through exactly how this process plays out? Really what Dr. Clark was talking about before, the options that are available, the other things like that, or not really?
So if they call Defence Archives or if they call 1800 Defence, which also falls under my responsibility, the staff member on either line will talk them through their options. If a particular individual is having difficulty completing the online form, they'll even assist by helping make the request on their behalf and then simply obtain the required identity documentation.
For how long has this process been in place?
Since I've been looking after this area, so since at least 2020.
Since at least 2020. And in terms of, does Defence maintain regular contact with family members after a request for information is made?
We, as I said earlier, aside from periods of significant bulk requests, we meet our KPIs routinely. That is communicated back by confirmation email when the request is made, so that the customer is clear on what timeframes to expect. If we're having difficulty, we would then communicate with that individual. But our requests, certainly in recent years, are generally speaking within the KPI, so not really any need to do that.
So, and just in relation to the freedom of information requests, again, there's a statutory time frame for them to be processed within. Yes. Defence meets that time frame in around about 90% or more of cases, and because it's a statutory requirement, there's always a formal decision provided to the applicant, and if there are any complexities with the application, our team would be in touch with the applicant to try to clarify and understand exactly what they're after.
At the outcome of the request process, is Defence quite clear about the fact that the information that's provided might not be a complete suite of information? There might be substantial parts that are redacted, not provided. Is that something that's explained?
So in the case of a freedom of information request, there is a formal decision that's provided to the applicant. It sets out what has and has not been provided, including what redactions may have been applied. Those redactions typically are under Section 47, but there are a range of provisions within the Act for that.
I think that's at the end. That's the end of the process. So that's when you're told this is what you're getting and not getting. I'm just talking about the expectation management. Really, at the beginning, is it explained?
Yes. So in the case of the freedom of information section of the website, it explains that there are these legal restrictions that may be applied in certain circumstances.
Yep. So that's freedom of information on the website. What about administrative requests?
I would need to confirm. I believe on the application form there is a section that outlines the requirements to comply with the Privacy Act, but I would need to confirm. I would say from a Defence Archives perspective, we receive around 40,000 requests per annum. About 40% of that is for DVA, and then for internal purposes, the next largest following that ex-members. The volume of requests from third parties or families is quite small, and those that are unable to meet the proof of identity requirements is no more than a handful per year.
Can I ask then, what are the, moving on from some deceased members in terms of living members, are there certain restrictions that apply if a family member wants to request information about a current member or a former member that's actually still living? Is that information provided by Defence?
From a Defence Archives perspective, it would not be without the member's consent.
Okay. And likewise for freedom of information,
it'd be the same. So you'd need the member's consent for that. Would that then be sought from, let's say a request of that nature were made, would that then be sought from them, or would it just be something that's already on the file as to whether they've provided their consent or not?
I don't have that level of detail of knowledge.
Neither do I.
Do you know if members are asked upon joining or at any time while they're in defence whether they consent to their information being shared with anyone in particular or in certain circumstances?
Not to my knowledge.
I'm not aware.
Is there any circumstance where, what about a member being at risk of, where they're identified within defence as being at risk of suicide? Is there any circumstance where that information would be shared with next of kin or family without the member's consent?
I think that would be a question for Joint Health Command.
Right. I'd have to ask Joint Health Command that question. I might then, just in the interest of time, turn to you, DVA, and ask some questions around this. Operator, can you please display doc ID DVA.5014.0003.0017? Now, can you see this on your screen? Or this is actually the flow chart that exists within DVA. Do you have it in front of you?
I do.
Fantastic. So this is a flow chart which depicts DVA's general guide to processing requests for the personal information of a deceased person. Is this an internal DVA document or is it published somewhere?
My understanding that it is that it is an internal DVA document.
Right. But it's your process that's followed by DVA when requests for information of this type are made?
Yes, it is.
Can I just ask just about the first question about that note at the top? So it says note, this flowchart provides a general guide to processing requests, but should not be followed strictly in every circumstance. The decision maker should exercise their own discretion in each situation. When is it not followed?
I understand that it is rarely not followed. An example of where a decision maker may use their discretion to not strictly follow it might be where there has been a significant passage of time between the client dying and the family member accessing the information. So, for example, if we receive a request from a great-great-granddaughter wanting to compile a family history about her grandfather and she would like to access personal information to support her to do so, then perhaps the level of detail required in this flowchart would not be required in that situation, but it would be quite different of a recently deceased client and a family member seeking access to their information.
That information would likely be much more protected than
Correct.
the other example that you made.
Correct.
So is it correct to say that it's only in very rare instances that this would not be followed?
It is my understanding that that is the case.
Okay. Just on that, how does DVA maintain any sort of consistency with the exercise of its discretion? Does it keep a record of?
When a decision maker applies their discretion, they seek the review and consultation and quality assurance from a more senior information access officer. And so that process, I guess, encourages a level of consistency so the decision does not rest with a single information access officer.
Right, okay. In terms of then, just looking at that flow chart and the two types of information, we've got financial information on the left and non-financial information on the right. So there are two different mechanisms, it looks like, for requesting information. Can you just briefly explain what's covered by financial information and what's covered by non-financial information?
And financial information is generally information about payments to the deceased person, any information about their financial or banking affairs. It does not include claims information such as the type of benefit that they may have received. Non-financial information may cover all other aspects of personal or sensitive information, including medical information.
Okay. And what's the process? So who does on this flowchart, it doesn't obviously have who the person contacts. So who do they contact within Defence if they want to access both financial and non-financial information? Sorry, within Defence, within DVA. If they want to access.
Can I please clarify, do you mean who does the applicant for
Yeah.
the information contact? So we have a single point of contact within DVA for information access requests, and that is our information access unit. There is a single there's a single email address for someone to make a request in writing. Alternatively, if they call our general inquiries number and they indicate they would like to submit a request, the staff manning that telephone line would put them through to the information access unit.
Okay. So it's if you want financial or non-financial, there's no two different.
No, it's
you just make one request. Okay.
Yes, correct.
Looking at the financial information side of that flowchart, am I correct in saying that a family member that has obtained a grant of probate or letters of administration and has also obtained a signed authority from each of the other executors or administrators, to the extent there are any, they're able to obtain the financial information of the deceased person?
It is my understanding, yes. That's correct.
Is it your understanding that that's wrong in any way?
No.
So I think that's also the case for a family member who is the named executor in a will.
Correct.
Right, so you don't need a grant of probate or letters of administration, provided you've got the consent of the other executors. That's enough. You're named as the executor in the will.
I understand that is the case, yes.
There also seems to be another way of obtaining that information, and that's without being an executor or administrator, and that if there is a compelling public interest reason, and that's in the blue box at the very bottom beneath the red one. What is a compelling public interest reason that would grant such access for DVA?
I don't have visibility of an example such as that.
Okay.
What I can say is that I understand that it would be a very rare scenario where that would be the case.
And in terms of that then, are those the only circumstances where a family member can obtain financial information, or is there another option? So let's say, for example, you're not the named executor, you're not the legal personal representative, you're just a mother or father of a deceased member. Can you go to DVA and obtain the information?
You can go to DVA and request the information, and we do have scenarios where a family member who is not the authorised legal representative requests that information, and in those cases what we would do is firstly encourage them to seek the consent of the family member who is the authorised legal representative. If that consent is not provided, which may occur in some of the more complex family dynamics, then generally DVA is not able to legally provide the information in those cases. But we are able to offer additional support. So we can offer to approach the legal representative and seek consent on the applicant's behalf if there is a complex family dynamic at play. So we do attempt to provide every level of support that we can in order for that information to be released, but at times we just don't have the legal right to do so.
Okay, so in each case where the answer that's received is no, because you're not the executor, and you then say to the person, but we'll help you reach out to the executor or we'll assist you, or is it just sometimes it happens?
I understand that we provide every level of support that we're able, and so if that means that we approach the executor on their behalf, then that's what we do.
Right. But if the executor says no, or if there is just no executor, let's say there's no will, and an administrator hasn't been appointed, it's there's just a gap there, isn't there?
There would be, and I think in those rare scenarios where there is no executor and no court-appointed administrator, we would, similar to our defence colleagues, look at the evidence of relationship, and that may include documents that we hold on file about any authorisation when the client was living that they might have provided to a family member to act on their behalf. So
that might actually overcome this process. That might be one of the circumstances in which the discretion might be exercised in favour of the applicant.
Potentially.
Can I ask then about the non-financial information side?
Yes.
Again, it looks like executors can access information, either with or without a grant of probate. But it also looks like a spouse can, so it looks like there's additional ways that you can access it on the non-information side, non-financial information side. And it says if the spouse is recorded in view or advance, is that just the system that DVA has?
Yes.
Right.
Yes.
And how would their name be listed in the system of view and advance? The spouse's name?
I'm not sure I understand the question, sorry.
The spouse's name would have to be listed in view or advance?
As I understand
As in DVA's system?
Yes.
I guess I'm asking, how does it get in there? How is it recorded on the system? Who provides the information that the person is the spouse?
I don't know the answer to that question.
Okay.
If I may,
Sure.
usually it would be provided by the veteran.
But the veteran's deceased.
Sorry, I thought you meant prior to.
No.
If we're looking back at a record.
Oh, sorry, I understand. Sorry. So if it's been provided prior to the veteran.
That's when it would be provided.
Yes.
I don't believe that it would be entered into the system once a client was deceased.
Yeah, so it would have to be provided at the time that the veteran is making their DVA claim. They might be asked who their next of kin is or who the spouse is, and at that time, that's how it finds its way into the...
Yeah, they may provide it as a part of the claim process. They may nominate the spouse to be a representative or have permission to inquire why they are alive, and that would be recorded on their record.
Okay. So it looks like a spouse can still access it even though they're not listed in the system and they're not named as the next of kin on the death certificate. That looks like there's perhaps a discretionary process that then plays out about evidence that's then applied. Is that right? So if a spouse comes to you and says, I am the spouse, and they're not listed as next of kin on the death certificate and they're not listed in view or advance, they're still able to potentially obtain the information?
It's certainly what this flowchart suggests, but it is my understanding that generally the release of non-financial information that is considered sensitive would still be subject to the applicant requiring to have that legal right to access.
Okay. So in practice, really, the answer's no?
Potentially, yeah.
Well, unless you've got the consent of the executor or the administrator, the answer's no. You wouldn't be able to, for example, produce a leasing form with the deceased member and say that you were living with them at the time or anything.
I don't believe so.
Okay, or other information or other material that might establish the relationship.
I don't believe so.
And just in terms of the just not being able to provide, on that side, in fact, under both sides, it looks like that unless the executors do provide that consent, and let's say you're a named executor, and there are two, and the other one says no, I'm not going to provide it. It looks to me like the answer sort of ends up with a no. Is there any circumstance where that answer ends up in yes, where executors are in dispute? Well, I say dispute, I don't mean dispute. When one just says, I'm not going to provide you with the consent for whatever reason.
There can be scenarios where DVA can provide support and intervention to reach a point where consent is provided, but I don't believe that if consent is not provided that we are legally able to release that information to the applicant who is not the legal representative, generally speaking.
And in terms of what is provided, are redactions applied to the information?
They may be.
And why would redactions be applied to the information? What would they cover? What types of restrictions apply?
So the reductions that may be applied would be as the categories that are set out under the FOI Act and the FOI guidelines. So it might be information that is subject to legal professional privilege, information that is outside of the scope of the request, business information, for example, fees that we might pay to particular medical providers, information that would be considered to unreasonably divert resources of the department, and in the DVA context, that is commonly where we redact the surnames of non-senior executive staff members.
And again, in terms of consistency, is that the same team that would apply those redactions in each case?
It is the same team, and a quality assurance process is undertaken in every request that we process, and so that includes all redactions.
Is there a review system if the applicant is unhappy with the redactions that have been applied?
It depends through which pathway they have requested. So if it's under the FOI arrangements, then yes, there is. If it's under administrative access, then no, there's not, and that is why we will often encourage an applicant to submit under FOI if we think that there would be significant reductions included as part of that, because it does offer them, I guess, a sense of protection in that there's review rights, but also greater transparency so they can see what we've redacted and why.
Yeah, I understand that. So in some circumstances, you would encourage people to go under the FOI process in those circumstances?
In those circumstances, we generally would, yes.
Because it's not, you would actually redact less under the FOI process?
It's not necessarily about redacting less. It's about providing the applicant with greater transparency and the
you provide
right to appeal.
Additional reasons and the
Correct.
right to appeal.
Yeah.
Do you provide those reasons under the administrative release system?
Generally not.
Generally
no.
not. In its response, DVA says that it doesn't have a standalone written policy for administrative access, which would be consistent with what you're saying about this sort of being just an internal document. Why is that?
I can't comment historically about why we don't have a standalone policy, but there are a couple of points I can make to that. Firstly, the information access officers follow the guidelines that are put out by the Office of the Australian Information Commissioner about administrative access release. We also make every attempt to align any information access requests that we receive, whether it's under FOI or not, to those types of requirements. And the other point I will briefly make there is that in February of this year, DVA stood up an information access unit which brought together all of the functions associated with information access into one team. And one of the things that is high on their list of priorities for this year is to firstly review all of the existing procedures and policies and also establish those where they're not in place, such as a procedure such as administrative access.
But you agree it would be useful to have a written policy
Yes.
governing your administrative release of information?
Absolutely, and that is why they are making that one of their highest priorities here.
Do you think there's any end date in sight on that, or is it just a priority at the moment?
I think that they are looking to review existing documents and develop new procedures, certainly during this calendar year.
I just have a few more questions. Just in terms of the consent, a DVA, when DVA are dealing with a member or veteran, did they ask the member or veteran at any point with whom they would like their information shared in the event of certain circumstances occurring, or?
I'm unaware if that question is proactively put to our veterans, but what I can say is that there is a form available on our website where a veteran can choose to nominate a representative to act on their behalf in various capacities, and one of those may include the release of information. Generally though, if we receive a written request for documents, we will still go back and undertake that third-party consultation with the veteran to ensure that that consent remains current, because relationships can change over time, and if we are releasing sensitive information, we need to make very sure that the living veteran consents to that.
So if there had been a previous consent, DVA would then make contact again to check that?
Generally speaking, depending on the nature of the request, but yes.
Okay. And that's just a form that's available on the website, but is it something that you know that is asked in each case when a claim's made, or it's not asked in each case?
Sorry, can I clarify what you mean by when a claim is made?
Yes, I suppose it's at some point throughout the claim process, I'm wondering whether the person who's making the claim is specifically asked, and with whom would you like this information shared, if anyone? What restrictions would you like to place on it or not place on it? Is there someone that you'd like us to be able to share this information with?
I don't know the answer to that question because claims processing does not sit within my branch.
Commissioners, I note the time. I'd just like to ask one more question of defence, and then I might ask you to ask some questions. We won't be able to get onto topic 3, unfortunately, but I can ask those questions at a different time or differently. Can I just ask, in paragraph 8 of Defence's response, it says that information released under administrative release remains official information and cannot be provided to a third party without Defence's consent. Is that all information that's released administratively? Does that limitation apply to all that?
My understanding is that when information is released administratively, it retains the classification or markings that were placed on the document. And the distinction that the author is drawing there is that when information is released under the Freedom of Information process, all classifications or markings are removed.
Right, sorry. So it's not a restriction on being able, let's say, for example, medical records are shared. It's not a restriction on that person's ability to share their own medical records with a qualified practitioner. They wouldn't need to seek Defence's consent for that. That's not correct. What that's right. So that's not what that's saying. It's not in reality a real restriction that Defence imposes upon in every single circumstance where documents are released administratively.
Not to my knowledge.
No, okay. It's just the markings on the page. I understand. Thank you. Commissioners, do you have any questions for the panel?
Thank you. Commissioner Brown?
Thank you. I have a couple of questions. Firstly, I just wanted to understand, I heard earlier that DVA needs to advise Defence when a claim has been lodged and then also again when it's been determined. I just wondered why.
Under the Military Rehabilitation Compensation Act, it's a requirement for DVA to advise the service chief, I'm pretty sure it's, of the claim and determination. Under the Safety Rehabilitation and Compensation Act, the Defence Rehabilitation Claims Amendment, it requires to provide a copy of the claim, and previous secretary has exercised their authority under Section 130 of the Veterans Entitlement Act to share with the Secretary of Defence claims and determination information. It allows Defence to exercise our duty of care to make sure that we are aware of medical conditions. There are incidents where a member will claim on DVA, but we may not be aware of the medical condition, but predominantly they're required by legislation.
Okay, so I appreciate the legislation, but I was looking for the underpinning rationale.
It allows us to exercise our duty of care to make sure that we are fully aware of the member's health condition. So when we're deploying the member or employing the member, we make sure that we are aware of any potential limitations that may put them or others in jeopardy.
Okay, thank you. My second question is in relation to, we've heard the details about the timeliness that you have been able to deliver, and I think we heard 75% in quarter 4 2020.
75% in the fourth quarter of 2020, we managed to the 75% of requests were responded to within the relevant KPI. So it depended on their urgency or their priority, but 75%. That's still 25% were late, and they will be late for the reasons we discussed before.
And we heard under FOI, Defence meets the statutory timeline in 90% of cases. I guess I'm sitting here wondering, therefore, why we hear so much about the delays in claim processing being because of difficulty in accessing records and information. I can't kind of reconcile the two, so can you help me?
I think I can. If you look back, or the evidence I gave before, in 2013, Defence was meeting that in 35% of the situation, 35% of the time. Since then, a significant amount of effort has been put in on both departments to improve the process of information sharing, and we've discussed the number of initiatives we've put in place to help speed that up to the point where we are, where we're at the moment. But there will always be requests that take time and sometimes considerable time, and may never actually be able to provide a response because the record may not exist anymore or may never have existed.
May I add to that?
Sure.
So I think the time that, in terms of claim processing time, for a delegate or a registration officer to request the information for it to go from DVA SAM team to Defence SAM team, for that information to then be collected and sent back, can take a period of time. So it essentially puts that claim on hold, awaiting that information to come back. The new system that we're implementing, the DDEIE and RMS system, will automate and streamline a significant amount of those processes and speed up that part of the process, so delegates will have access to that information in a much faster time frame. So while we have had exponential growth in claims, the new system should assist us with, I guess, timeliness and not, the delegate will get a claim, be able to request the information, get that information back in near real time in most cases, and then continue with that claim assessment rather than having to put the claim to one side to wait for that information to come back.
Well, that's certainly promising.
To add to, I mean, the other improvements, up to 2017, the information was burnt to DVD and couriered to DVA and then was uploaded, so there's time involved. Since then, we now use a defence application to electronically transfer the file, but there's still a person involved in doing that, so that still adds some time. The new system removes people from the link and allows the information to flow much quicker. So there has been a lot of work done to improve this, but as I said, some requests take time.
Sure. And my last question is just to understand, you said earlier in relation to, and I think it might have been the flow chart, but somebody said there's no legal basis for the release of information on a deceased if there is no executor or legal representative, I think. I just want to be very clear, what is the legal basis that requires that?
Do you mean under which legislation?
Yes. Yeah.
I understand that the legal basis on which DVA requires authority for someone to access personal information of a deceased client is actually a common law duty of confidentiality, and so that is in recognition that when the information was provided to DVA, there would have been a reasonable level of expectation and trust that we would treat that information confidentially and not disclose it inappropriately. And I believe that is the legal basis on which we look to seek that authority.
So it's common law rather than specifically in statute?
I believe so.
Thank you.
Commissioner Douglas.
The defence members of the panel might be able to assist me on this, but my understanding is that there's a practice within the Defence Force of encouraging members to execute a will, particularly before they go on deployment. Is that correct?
That is correct. That is correct. Thank you.
That's correct, is it?
That is correct.
Thank you. And perhaps the DVA people might be able to answer this. Does that have the effect that the large majority of people seeking to access information are doing so as executors?
I don't have visibility of that breakdown of data.
Okay.
And I can't answer that question.
Righto. Let's assume that somebody is either an executor or holds letters of administration, but there's a claimant for information who's at odds with, let's say, the executor. You can think of a number of typical examples, but you might have a child of a former marriage against the current spouse. Is there any regime for handling those sorts of disputes?
Each one of those requests would be approached in a way that reflects that particular scenario. So our information access officers, I know, are fully committed to providing the most support that they can to reach a positive resolution for all parties. Does that answer your question?
No, it doesn't. That suggests a very general discretion which might be applied, but is there any structure applied to it? Do you try to say, well, look, this person is clearly a child and should be entitled to the information in spite of what the executor's wish is?
We would reach out to the executor and attempt to obtain consent on behalf of the applicant.
Okay, it's not coming. It's not forthcoming.
Then generally in those scenarios, we would have no legal basis on which to release that information to that applicant.
Thank you.
Thank you. Just a couple of quick questions, if I may. Ms Hamilton, you mentioned earlier kilometres of information. Could you just, for the uninitiated, what is a kilometre of information?
So a piece of paper on its thinnest side, that many kilometres worth of
That's
paper.
a lot of paper, obviously. Yeah, understood. Okay. There was a question a little bit earlier, Commodore, I think you mentioned that when someone is medically discharged, you do not automatically convey all the information. And I mean, the ADF would have discharged that person medically, and they know that he has been discharged medically, and yet the information about his issues are not conveyed automatically to DVA. It's only conveyed on request. Happy to be corrected. Have I got that right?
That is correct. Remembering too that the member may not have, the medical reason behind the member's separation may not be service related.
So the policy is not to convey information on a general basis about an individual that's been medically discharged to DVA, knowing that he's been medically discharged for some medical issue.
It's my understanding that we don't automatically
it has to be requested.
Pass on medical records unless there is a request either from the member or from DVA in response to a claim.
Do you think it would make sense for that information to be conveyed automatically in cases where someone's been medically discharged and the ADF must be aware that he's been medically discharged?
We are aware the member's been medically discharged. May not necessarily.
May I offer?
Yes.
Because it comes down to the member may not, the medical condition may not be a result of the member's service. So therefore it may not be a claim on DVA.
My understanding is that if, as we said under the early engagement model, DVA is notified both at enlistment and at transition or separation, and we do reach out to the veteran at that point. There are a number of circumstances where that happens prior to the discharge or separation date, and we make contact, so that information wouldn't be provided, but we would reach out to the veteran to see how we could support if they were being medically discharged, and therefore if they chose to make a claim at that time, we could request that information.
Thank you. Just one other question. It's probably for Dr. Clark. You mentioned earlier that, I think you answered rather a question in relation to paragraph 8 of Defence's response about information released in an administrative release which cannot be shared with third parties. But your view is that it can be shared with someone who may be his doctor or her doctor or lawyer or whatever. Is that the case?
If that information is the individual's information, yes.
Is that articulated anyway? The fact that it can be shared?
I'm not aware of that. I'd have to do some digging.
Well, I appreciate if you can take it on notice. Yeah. Thank you. Thank you. I think that's it from us. Mr. Fordham, anything to raise? No? Yeah. Mr. Sheffield?
It's gone off again, sorry. May each of the panellists please be released from their summons.
Thank you. Thank you.
All rise. The Royal Commission will now adjourn. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Mr. Shefter.
Commissioners, I call Ms Angeline Falk, the Australian Information Commissioner and Privacy Commissioner.
Commissioner Falk, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Commissioner Falk, am I correct in saying that you have held senior positions in the Office of the Australian Information Commissioner since 2012?
That's correct.
And that you served as Deputy Commissioner from 2016 and Acting Information Commissioner and Privacy Commissioner from March 2018?
That's correct.
And in August 2018, you were appointed the Australian Information Commissioner and Privacy Commissioner. And since that time, you have led the office in fulfilling its relevant legislative functions.
That's correct.
And you're also a member of the National Data Advisory Council.
I am.
And you sit on the Executive Committee of the Global Privacy Assembly as well.
I do.
And you chair the Assembly's Strategic Direction Subcommittee and co-chair its Digital Citizen and Consumer Working Group.
I do.
Commissioners, today's examination of Commissioner Falk will focus on 3 topics, and they're broad topics. It'll be an overview of Commissioner Falk's role as the Australian Information and Privacy Commissioner and the functions of her office, Commissioner Falk's views as to best practice in terms of collecting and sharing personal information, and certain legal issues or limitations which operate when information is shared or sought from government agencies. I should mention a particular limitation on the evidence of Commissioner Falk, and that is Section 29 of the Australian Information Commissioner Act. Broadly speaking, that section prohibits Commissioner Falk from giving evidence here today about information or knowledge that she has acquired in the course of performing her role as Information Commissioner and Privacy Commissioner. And so I won't be asking any questions this afternoon which traverse into that territory. I should also add that after certain concerns were raised by the Commonwealth late last week, that I also do not presently propose to ask Commissioner Falk to express her opinions about what improvements might be made to specific defence and DVA information sharing arrangements. Commissioner Falk, just turning to today's first topic, can I please ask you to tell the Commissioners what the key functions of your office are?
The key functions of the Office of the Australian Information Commissioner are set out in the Australian Information Commissioner Act. They are the FOI functions, the Freedom of Information functions, which are about giving the Australian community access to information held by the Commonwealth Government in accordance with the Freedom of Information Act. The second is the privacy functions, which are primarily about protecting the privacy of individuals in accordance with the Privacy Act and other acts. And also the Information Commissioner functions, which are strategic functions concerning information management by the Commonwealth Government.
Commissioner Falk, I see that you're just reviewing a document in front of you. Is that the summary document that you provided to this commission this morning?
Yes, it is.
Commissioners, that document was provided this morning. It hasn't therefore been processed and been provided with the document ID number, but I'd like to tender it. The document's called Summary Document from Australian Information Commissioner and Privacy Commissioner, Royal Commission into Defence and Veteran Suicide.
Thank you. Will be accepted and allocated the next number.
Thank you. Commissioner Falk, can I ask you to now tell the Commissioners a little bit about your role as Commissioner, including your respective functions under the Privacy Act and also under the Freedom of Information Act?
Thank you. So under the Australian Information Commissioner Act, I'm the agency head of the Office of the Australian Information Commissioner. I'm appointed as both the Information Commissioner and also the Privacy Commissioner, and I exercise all of the three functions that I previously outlined: the Information Commissioner functions, the Freedom of Information Commissioner functions, and the Privacy Commissioner functions. In terms of the privacy functions, those functions are conferred by me under the Privacy Act and other related laws of the Commonwealth, and they traverse a broad range of functions and activities. I have responsibilities for providing guidance on the operation of the Privacy Act, to monitor certain operations of regulated entities, handling of personal information, and also to provide advice to regulated entities on matters relating to the operation of the Privacy Act. I also have a range of regulatory powers under the Privacy Act, and if I can take a user-centric approach to describe those, we run an inquiries line which allows individuals to access information from the OAIC. An individual may also make a privacy complaint to my office, which we would consider and seek whether it was appropriate to conciliate, or I can make a binding determination which is enforceable in the federal court, which sets down whether or not an entity has breached the Privacy Act. I also have powers to take action in the federal court for a civil penalty proceeding.
Thank you. In your summary document, you refer at paragraph 2.1 to saying that what constitutes best practice, and this will come to this, but in terms of information sharing and storage, etc., is heavily context dependent. And so you refer to what is ultimately better practice approaches. By context dependent, I suppose you mean it depends on the particular government agency and the particular information that's requested as to what would comprise best practice in those circumstances?
Yes, so the Privacy Act contains 13 principles which regulate the handling of personal information by those government agencies that are subject to its jurisdiction. They follow a life cycle approach from ensuring that there's a privacy policy that explains to individuals how their personal information will be handled, that individuals are giving notice about those practices, and then traverses all of the information life cycle from collection through to the storage of that information, individuals' ability to access and correct their information, through to the destruction of the information. It's a principles-based law, and it incorporates a number of concepts such as the taking of reasonable steps, and that allows each government agency to create the processes and practices to comply with the Act that are appropriate to their particular context. So, for example, a government agency that collects a large amount of sensitive health information is likely to require additional protections of that information than a government agency that does not contain that kind of sensitive information. In terms of compliance versus better practice, my office has released guidelines called the Australian Privacy Principle Guidelines, and they set out my view as to the mandatory requirements under the Privacy Act, those matters that must be complied with. But they also set out my view of what action agencies should take in order to comply and promote better practice, as well as options for agencies. And to give one example that might assist the Commission, under the Australian privacy principles, agencies ought only collect information that's reasonably necessary for their functions and activities. And a best practice approach to that would take a risk-based approach and ensure that only necessary information is collected, and thereby reducing their risk of a data breach occurring in relation to that information. So in that way, the data minimisation principle, taking a best practice approach to that, also ensures a better practice to the security of personal information.
Thank you. In terms of sharing personal information, and let's perhaps start with the Privacy Act, you refer to the Australian privacy principles, and there's a sharing information privacy principle, isn't there? It's APP 6.
That's correct.
What does best practice look like in terms of sharing information in accordance with that principle?
So the principle in Australian Privacy Principle 6 is the principle that applies to both the use and disclosure of personal information. So disclosure occurs when a government agency releases from its effective control information in its possession. The Privacy Act primarily starts from the proposition that an agency collects information for a primary purpose, and it shouldn't disclose that information for a secondary purpose unless certain circumstances apply. So one is where the consent is obtained from an individual. And in order to ensure that consent is obtained in a way that's both compliant and better practice, it ought to be consent that is fully informed and freely given, that it's also point in time, consent to the particular information handling practices. There are other exceptions that also allow disclosure. They relate to the reasonable expectations of an individual and whether that disclosure is related or directly related to the purpose of collecting that information. And there are other exceptions that relate to what are known as permitted general situations. For example, where there may be specific concern that information needs to be disclosed in order to prevent harm arising to an individual. So a better practice approach to that is to have the processes and policies in place that set out clearly when each of those circumstances will apply in the agency's context.
Thank you. Just on that exception that you raised, and it's where personal information needs to be used or disclosed to lessen or prevent a serious threat to life, health, or safety. Does that include those persons who are at risk of suicide or who are identified as being at risk of suicide? Would that be a circumstance that would permit a government agency to share information about that person?
So to the extent that that is a serious threat to life, health or safety, then it would permit the sharing to occur where it's unreasonable or impractical to obtain the consent of that individual.
For example, if there were an urgent time imperative or something like that.
It will be context specific and mindful of speaking in the abstract. But the test is if it's impracticable to obtain the consent, and there needs to be a reasonable belief that's held that it is necessary to lessen or prevent the serious threat to life, health or safety of an individual.
Is there any legal restriction on who that information could be shared with by that government agency?
The Privacy Act does not set out a list of authorised recipients. What it does is it provides a framework where what might otherwise be unlawful handling of personal information would be found to be permissible through the operation of an exception. So the recipient of the information may be relevant to whether the exception applies in the particular circumstances.
And I think I'm correct in saying that a related Australian privacy principle is number 12. What does best practice look like in terms of requests for information under APP 12?
Australian Privacy Principle 12 is the principle which allows an individual to access personal information about themselves. In terms of best practice for complying with that, again, I go back to Australian Privacy Principle 1, which requires all agencies to have in place the processes and procedures and systems that enable them to comply with the privacy principles generally. So there ought to be information available for officials within the agency as to how to process requests for personal information. And then there ought to be processes set out that go to such issues as the way in which an individual can identify themselves to access their own personal information, and also the timeframes. So a request for access to one's own personal information needs to be responded to within 30 days.
Can I ask, it would be best practice, wouldn't it, for each government agency to have clear written policies concerning the release of information and requests for information, wouldn't it? Whether it's under FOI, whether it's under the Privacy Act, whether it's under an administrative request function. A clear written policy would be best practice, wouldn't it?
Yes, best practice is to have clear written policies so that individuals are easily able to see the mechanisms through which they can access their own personal information.
Just stepping back to APP 12, in paragraph 2.26 of your summary document, you refer to APP 12 operating alongside a right to access under the Freedom of Information Act. And then you say, however, in practice, agencies more generally provide access to personal information under the FOI Act. Why is that?
APP 12 provides a right of access, as I said, to an individual's own personal information, whereas the FOI Act provides a right to access documents held by an Australian government agency or a minister in certain circumstances. It's not limited to personal information. So in practice, many requests to government agencies traverse both an individual's own personal information and personal information of third parties or non-personal information. The other reason why I would say in practice, whilst APP 12 is applied by agencies, there are more requests processed under the FOI Act, is because APP 12 contains an exception which allows government agencies to consider the access exemptions under the FOI Act. So in that sense, the FOI Act exemptions can be considered by an agency, but if the request is made under APP 12, then the reasons are provided under the Privacy Act, and it's the Privacy Act review mechanisms that follow.
There's no, if you do want to make an FOI request, there's no obligation to request it first under a different mechanism, for example, under an administrative process or under the APP 12, if it's your own personal information, is there?
There's one situation where there is a requirement under the FOI Act, and that is set out under the FOI Act at section 15A, and that provision makes specific reference to personnel records to an employee or former employee of an agency. So if such an employee or former employee is requesting documents about themselves, then section 15A of the FOI Act requires that they first access any established procedures in the agency, sometimes known as an administrative access process, before requesting the information under the FOI Act. But that limitation does not apply under the Privacy Act.
Thank you. In terms of requests for information that are made under the FOI Act about a deceased person, the Privacy Act doesn't operate to prevent that information from being released, but there is a personal privacy exemption in the FOI Act, isn't there?
That's correct.
And when does that operate?
So the personal privacy exemption may be applied by a government agency if an FOI request is made to a document that contains the personal information of a third party who's not the applicant.
And in terms of, so that's the only, but in terms of the deceased person's information, there's no reason why that wouldn't be provided under the FOI Act.
It's not as simple as that. So personal information, the definition of personal information under the Privacy Act does not extend to deceased individuals. So the personal information of a deceased individual cannot be accessed through the Privacy Act mechanism. However, information of a deceased individual could be requested under the FOI Act, and a decision maker would still be required to consider the impact on that deceased person's personal information. A deceased person is specifically included within the ambit of the FOI Act.
And in making that assessment, am I right in saying that they would have to find that the disclosure of the information relating to the deceased person was contrary to the public interest?
That would be the second part of the test. So section 47F that you've referred to, the personal privacy exemption in the Freedom of Information Act, is what's known as a conditional exemption. That means it is subject to a public interest test. But the first part of the test is to consider whether the disclosure of the information would have an unreasonable impact on the privacy of that deceased individual. And there are specific procedural matters set out in the FOI Act for consultation with a deceased legal representative. And they're set out at section 27, capital A of the FOI Act. If after considering those matters, a decision maker was of the view that the information was conditionally exempt, that is, it could unreasonably impact the privacy of the third party, of the deceased individual, they would then need to consider the public interest and where that lied in the specific circumstances.
I think at paragraph 2.33, you set out the circumstances that must be considered as to whether there is unreasonable disclosure of personal information. And the factors that you identify there are, to the extent the information is well known, so that's the information that's well known about the deceased person.
That's
the availability of the information from publicly accessible sources. Again, we're referring there to things like articles, Google searches, things like that.
Right, yes.
Facebook, those sorts of publicly accessible information would also be taken into account?
It could be.
And then finally, and whether the person to whom the information relates is known to be or have been associated with the matters dealt with in the document. What does that last factor require the person to consider?
In some ways, it's related to the previous item. The factors to whether the information might already be publicly known or the person is generally known to have been associated with the particular matters that are set out in the document. So the extent to which the disclosure of this information would be a revelation of some kind beyond the knowledge of the individual concerned.
And are there any other factors that would be taken into account? Typically?
There are other factors that could be taken into account. It is, as I say, context specific. All of the facts and circumstances would need to be considered. The Freedom of Information guidelines that are made under Section 93A of the Freedom of Information Act, which public sector agencies must have regard to when they're exercising their decision-making functions under the FOI Act set out a range of factors at Chapter 6 of those guidelines.
So we have, thank you for that. So we have there an exception which protects the privacy or may not require or may prohibit the provision of information about a deceased person in certain, so quite limited circumstances, because there's a second limb to that test, which also must mean that it's not in the public interest. Are there any other legal reasons why a government agency cannot simply share personal information about a deceased person, for example, like via an administrative release rather than under the FOI Act or any other act, with a family member of that person?
I'm not able to specifically give evidence on other laws that may or may not apply. There may be, for example, secrecy provisions that apply to government agencies that may have work to do. There may also be some common law obligations of confidence that might apply depending on the circumstances, if we're talking about medical information, for example. But I can point the Commission to the FOI Act and Section 3A of that Act, which does provide that if an agency has the power to give access to a document apart from this Act, then Parliament doesn't intend by the FOI Act to limit that power or to discourage the exercise of that power.
Can I restrict I understand that what you say about the fact that you can't give evidence about other acts or other common law equitable obligations that might preclude information sharing. Can I limit it to the acts that you really oversee, the Privacy Act and the FOI Act? Apart from that exemption that we just spoke about, there's really nothing in either act apart from that would preclude the information being provided administratively.
So if I can perhaps take the question in this way, if I may. The FOI Act contains a number of exemptions. As I said, there is a right to access documents unless the document is exempt. It starts from the proposition of a pro-disclosure disposition for decision makers. But there are other exemptions that may have work to do. For example, if the information relates to matters of national security, that might be an exemption that could have work to do. Information provided in confidence, and also if the information, for example, was to contain information around complaints that may have been made by others against an individual, or processes that are still at play, then there is an exemption at Section 47E of the FOI Act, which looks at whether or not disclosure would have a substantial impact on the operations of an agency. So if we go back then to the consequence of that, if information, if a document might contain that level of complexity of information, the risk is in providing it under administrative access is that an agency may decide to redact large portions of that. And from an individual's perspective, the individual doesn't receive a statement of reasons under the FOI Act, nor the review rights that attach to a formal decision made under FOI.
But I think I understand what you're saying in terms of under the FOI Act, unless provided that no other exemptions apply, the document could be released. If the request is made under the FOI Act. If it's not made under the FOI Act, then there might be other privacy reasons as to why particular information is redacted, but there's not a legal impediment apart from those other ones that you've mentioned.
I think the point that I'm seeking to make is that information that's released under the FOI Act may be redacted where certain exemptions are found to apply. They might be around third-party privacy, they might be around national security and the other examples that I mentioned. If that's the case, an individual applicant would be given a statement of reasons, a schedule of documents. They would have each of the redactions would be annotated with the relevant exemption that's applied, and then that they have an opportunity to have request an internal review by the agency of that decision by someone who hasn't been involved in the original decision, or they can seek merits review from my office around that decision. Those review rights do not pertain to information released under administrative access.
Thank you. Just as a, perhaps noting the time, a final question from me before I ask the commissioners to ask you some questions. What does best practice look like in terms of incorporating a trauma-informed approach to dealing with requests for personal information under the Privacy Act and the FOI Acts?
The point that I'd like to make in relation to a trauma-informed approach is that the Privacy Act and the FOI Act both allow applications to be made on behalf of an individual. It also requires, under the FOI Act, agencies to take steps to assist the individual in their formal application, and also to direct them to another agency if, for example, the individual finds that they've made the request to the incorrect agency. And then under both the Privacy and FOI Acts, there is an obligation for my office to assist individuals. So to the extent that my legislation intersects with the notion of being trauma-informed, both of the pieces of legislation would anticipate that agencies can put in place systems and processes to support individuals to access information.
In essence, though, it is up to the relevant government agency to adopt those particular policies.
Under the FOI Act, there is a specific obligation to take reasonable steps to assist. And if an agency was not taking those reasonable steps, a complaint could be made to my office about that matter.
And actually, finally, I will ask, just because you've raised complaints, I will ask you, how is the performance of an organisation against the Privacy and FOI Acts measured by your office?
In relation to privacy, the way in which personal information is handled, the Privacy Act contains some proactive obligations that I've already traversed around Australian Privacy Principle 1, where there's a requirement to have processes and procedures in place up front. Agencies are also required to comply with the Australian Government Agency's Privacy Code, where they need to have a privacy contact officer, a privacy champion, and also a privacy management plan in place. In terms of monitoring compliance with all of those requirements, we do that through the complaints that are received by my office. Also, I have powers to conduct assessments, otherwise known as audits, of government agencies, and can do so if, looking at the complaints and other intelligence, it's warranted in the circumstances, or if I'm specifically asked by government through funding to conduct assessments of those entities. In terms of the FOI Act, there's specific requirements under the FOI Act for government agencies to provide statistics to my office on FOI processing, the volume of numbers of applications, as well as the numbers of access grants, access refusals, in part and in full. And so my office analyses those statistics. We also can receive, as I've mentioned, complaints under Section 69 of the FOI Act about the way in which an agency has approached or handled an FOI request. And finally, where there is a decision by an agency under the FOI Act that is reviewable, what's known as a IC or Information Commissioner Review, to my office. And those decisions, if they proceed to a full decision, are published on our website, and they provide precedent for agencies as to the operation of the FOI Act.
Thank you, Commissioner. Commissioners, do you have any questions for Commissioner Falk?
Thank you. Commissioner Brown?
Thank you, Commissioner. I just wanted to ask, we have been advised by some individuals around the practice of information of current serving ADF members being required to be shared with their chain of command. And I'm thinking particularly some circumstances around, health information. Just wondering where that fits within the Privacy Act or whether it is separate to that.
I'm sorry, Commissioner, I object to that. There's an issue in that because of the review powers that the Commissioner has, if she delves into detail in relation to particular scenarios and then has to make a similar determination at a later date, that may cause some apprehension.
Okay, thank you. I'll withdraw that question then. My second question possibly goes to the same place, so I'll have no further questions. Thank you.
Sorry.
Commissioner Douglas.
The question I had in mind could raise similar issues too, so I think I'll leave that to my own imagination.
I have no questions, Commissioner, but just thank you for your evidence today. Subject to Mr. Fawn, was there anything you want to raise? No.
No, thank you.
If there's no matters arising, then the witness might be excused from her notice to attend.
Thank you, Commissioners.
Thank you again. We're going to adjourn till 9:30 tomorrow morning, I believe.
All rise. The Royal Commission will now adjourn until Tuesday the 12th of April at 9:30 a.m.